Good morning, sir. Hopefully you can see and hear us.
Yes, I can. Thank you.
Thank you. We'll be hearing from Mr. McCall this morning.
You could stand, please. Bible in your right hand and repeat after me. I swear by Almighty God
I swear by Almighty God
that the evidence I shall give
that the evidence I shall give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Thank you.
Thank you.
Please could you state your full name?
Kenneth McCall.
Mr. McCall, in front of you there should be a witness statement. Do you have that?
I do, thank you.
Firstly, can I thank you for providing that written statement and for attending the inquiry today to answer questions about it. Before I ask you to turn to your signature, I understand there's one small correction to be made. Please could we have on the screen page 30, paragraph 65 of the statement. In that paragraph, you say at the start that you received Mr. Cooper's call at around 8 o'clock, and we'll come to this section in the course of your questions. Just for the purpose of the correction, midway down the paragraph, it says, shortly after the call with Mr. Parker, I rang Ms. Stent, and I understand that you wish to change that to shortly after the call with Mr. Cooper. Is that correct?
Yes.
Thank you. That can come down from the screen. Thank you. Mr. McCall, can I ask you, please, to turn to page 35 of your statement? Do you see a signature?
I do.
Is that your signature?
It is.
And subject to the one correction we've just made, are the contents of that statement true to the best of your knowledge and belief?
They are.
Thank you. That stands as your evidence in the inquiry. It will be published on the website shortly. And for the purpose of the record, the unique reference number is WITN 100200100. I'm going to ask you some questions about it, but not all aspects of it. I'll start with your background, well, actually your role at Post Office Limited. You were the Senior Independent Director of Post Office Limited from January 2016 to January 2022. Is that right?
That's correct.
Then looking at your background, you spent the first part of your career at TNT. Is that right?
That's correct.
And you became the CEO for Asia and then CEO for China at TNT.
I did.
You joined DHL in 2007.
Correct.
And you then joined the Eurocar Group, becoming Deputy Group CEO in 2016.
That's correct.
So was that an executive position at Eurocar?
Europcar was an executive position.
And what was the time commitment for that role?
I was a full-time executive at Europcar on a normal basis, 5 days a week, or as required.
And in practice, was it a 5-day-a-week job, or did it involve weekend work as well?
It involved weekend work as well.
You have been you had been a non-executive director at Superdry, is that right?
That's correct.
When did you begin that role?
From my witness statement, it would be 6 years prior to then, I recall. So I served 2 terms at Superdry, joining the post office in 2016, so it would be 2010.
And was there any overlap between your Superdry appointment and your appointment as Senior Independent Director at Post Office?
No, I don't recall there being so.
Did you have any other non-executive roles whilst you were at the Post Office?
I did not.
I understand that your contractual time commitment as Senior Independent Director was 2 days per month whilst at Post Office.
That's correct.
Did you have sufficient time to meet your commitment to the Post Office, given your executive commitments to Europcar?
Yes, I did.
You say in your statement at paragraph 9, we don't need to bring it up on the screen, that Tim Parker thought you would be a good fit at Post Office, and you refer to your experience in parcels and mails. Yes?
Yes.
At that point, later in your statement, you also refer to having some experience of dealing with IT issues at an executive level. Is that right?
Yes.
Could you briefly just summarise what that IT experience was?
My IT experience, I was responsible at Europcar Group for the business priorities of the IT function, which was headquartered in Paris. So I would decide exactly what the business required of the IT department and liaise with them.
Did you find that experience assisted you in your role as a senior independent director at the Post Office?
From a business perspective, yes. From a technical perspective, not necessarily.
And why not from a technical perspective?
I'm sorry, a big one?
Why not from a technical perspective?
Because my role at Europcar wasn't a technical role. It wasn't deciding systems or otherwise. It was purely, what does the business require? What do our customers want?
When you were a senior independent director at Post Office, do you think its board had sufficient technical IT experience to handle the issues before it?
Yes, I do. We had an excellent CIO, Mr. Houghton. I had two fellow non-executive board colleagues who came from the IT and technology sectors, and therefore at least two of the board, to my knowledge, were very IT savvy and knowledgeable.
You say in your statement that to the best of your knowledge, the companies you had worked for prior to the Post Office did not pursue private prosecutions.
That's correct.
Was there anyone on the board with legal experience or qualifications?
Latterly, I believe, if I recall correctly, a year before the end of my second term, we had a non-executive director join, who's still there, I believe, at the present time, who is from the legal profession.
Can you name that person, if you can remember the name?
I don't immediately recall. Yes, I do now. Mr. Tidswell.
Do you think the Post Office board would have been assisted by having a member of the board who had legal experience or qualifications, considering the matters you were dealing with during your time there?
I believe that latterly the assistance of Mr. Tidswell was extremely helpful in guiding the board through some of the processes. So, yes,
I suppose you there. When you say some of the processes, what processes are you
I think
referring?
Understanding what decisions we require to make and why, and how to maybe understand a bit better the details.
The details of what?
The details of the options that we had.
I'll ask it another way. Are you referring to legal issues to which this inquiry relates, such as compensation and criminal appeals?
Yes.
Do you think it would have assisted the Post Office board then to have experience such as that on the board when you were dealing with the group litigation?
At the time when I joined the Post Office board, I did not know anything about the group litigation, so therefore, in joining, I wouldn't have had an opinion that said we would benefit from having legal expertise. Having then gone through the group litigation, I would say yes, it would have benefited the board.
I want to look at your role as the senior non-executive director. So the inquiry has heard evidence that, and is well aware that both the shareholder executive and then UKGI appointed a shareholder non-executive director to represent its shareholding interest at the board, correct?
Yes.
As a non-executive director, in whose interest did you act?
In the interests of the shareholder.
And in order to act, how did you determine what those interests were?
In a company that's either a listed company or certainly multi-shareholding, you're acting on behalf of that as a shareholder. In this case, in the government company, I was acting on behalf of the government shareholder to bring my expertise and experience to bear on a post office board.
The government shareholding interest in Post Office Limited wasn't simply to see Post Office making a profit. Would you agree with that?
That statement was never something that was in my terms of reference or was never made to me specifically. My view was that my role was to try and ensure a sustainable business model for Post Office looking forward.
Can you summarise, in your view, what distinguished your role as Senior Independent Director from that of the other non-executive directors?
I was responsible for reviewing the performance of the chairman. I was the conduit for the other non-executive directors if they needed any help or advice. In some ways, I was the go-between also to the chairman, where I would advise the chairman if there were any concerns of the non-executive directors. So, in simple terms, I would say at a high level, I was eyes and ears.
The responsibility you referred to of evaluating the chair's performance, in one way that was carried out through yearly evaluations, is that right?
That's correct.
Would you see your responsibility for evaluating the chair's performance as an ongoing matter, though? You had to keep on top of the chair's conduct and effectiveness.
Yes, in principle. I think through the COVID period where we were meeting remotely, I don't recall exactly the process we went through, but through the COVID period it was extremely difficult. It was about survival and it was about trying to keep a business together. So I don't recall specifically the chairman's performance review. When it was done face-to-face, I recall it quite specifically.
In your role as non-executive director and protecting or acting in the interest of the shareholder, to what extent did you have meetings with the minister with responsibility for Post Office in your role as Senior Independent Director?
I don't recall how many meetings I had with the Postal Minister. Possibly one or two, nothing more. And again, please bear in mind that through the period we had 3 years of COVID as a part of that exercise, so therefore no one was meeting anyone face-to-face. I met the chairman of BAYS, at that time, I believe now BIS, and I met possibly one other minister as a part of that exercise. So I didn't regularly meet a postal minister.
Before the hand-down of the Common Issues judgment in March 2019, had you had any conversation with the Postal Minister or indeed the Secretary of State about the allegations concerning the robustness of the Horizon IT system or the group litigation?
No, I don't recall I did.
To what extent would you meet representatives of the shareholder UKGI, outside of meeting Tom Cooper in board meetings?
I would meet possibly Richard Callard, who first was the prior to Tom Cooper. Tom Cooper afterwards, either for a coffee beforehand or after a board meeting. I don't recall any formal meetings at their offices as a part of that. I had a conference call once with the Permanent Secretary, but other than those, I don't recall any.
The conference call with the Permanent Secretary, do you recall when that was?
I don't recall the specific date.
Did you discuss issues relating to the allegations of a lack of robustness in Horizon or the group litigation?
No, I did not.
Do you recall what you discussed?
Frankly, I can't remember the date. I can't recall the date, so I think I would just be hypothesizing. So, no, I don't remember.
Please could we bring up your statement at page 5, paragraph 14. You're referring to your role and responsibilities as a non-executive director, and at the end of paragraph 14 you say, at a high level, my role as a non-executive director was to be part of a board developing Post Office's strategy to achieve financial self-sustainability and to work with the management team to deliver that. And then over the page at paragraph 16, go down, please. Towards the bottom half of that paragraph, you say, our role as non-executives on the board is to help determine the company's future direction and strategy. In other words, we are focused on what the company might look like in several years' time and how we can create a sustainable and future-proof business. So strategy is forward-looking. Would you accept that to be able to advise on strategy, a non-executive has to consider risk to the business arising from past liabilities or current operations?
From a strategic point of view, the focus of a non-exec will be looking at the marketplace that the business operates in, the business model that it's using in that marketplace, and how we might improve that business model to ensure that, in this case, the Post Office remained a leading player in the mails, parcels and logistics market. And that was the focus of sustainability as a business.
Do you think that following the hand down of common issues, the Post Office's future strategy and its sustainability changed as a result of that judgment?
After the common issues judgment, there was, I believe, about 8 or 9 work streams that were started as a result of the common issues judgment, looking at the remarks and comments made by Justice Fraser and the requirement for the Post Office to substantially change its way of operating and its relationship with the sub-postmasters.
So I think you're agreeing with me that things changed significantly following the common issues.
There had to be significant change.
The common issues judgment considered and made findings on matters that happened in the past. Would you agree?
Predominantly, yes.
So was it not the role of the board, including the non-executives, to look at the past as well, to determine what risks in future, or assess what risk in future may be on the horizon?
As a non-executive, I'm always looking at forward, not looking back, and looking at our business model. And in this case, after the Common Issues judgment, we're looking at what changes required to be made that was the result of the judgment. And so that was really the focus, as opposed to looking historically.
Do you think the executive team had a role in identifying, analysing and mitigating risks for things that happened in the past?
The executive team, from the outcome of the Common Issues judgment...
Stop you there, sorry. I'm not talking out from the Common Issues judgment here. As a matter of generality, when you joined the Post Office in 2016, did the executive team have a responsibility to identify, analyse and mitigate risks that the Post Office Limited faced?
Yes, as a general principle, yes.
Did the non-executive directors have a role in overseeing that aspect of risk management?
Yes, mainly through the Audit and Risk Committee.
And what did you see as the non-executive director's role in challenging the executive team's delivery of its operations?
The robustness of the strategy, the business operating model, the product evaluation, the customer service requirements, the detailed operating requirements of running a business, and what we had to change and what the executive team were focused on day to day.
So did the non-executive directors, including yourself, from 2016 onwards, have a role in overseeing the executive team's analysis of the risk posed by the Horizon allegations?
When I joined the board in January 2016, I was completely unaware of the Horizon issues, bugs, and historical problems. And therefore, in my mind, when I joined in 2016, my focus was on building a sustainable business model and future. It wasn't focused on looking back. I was completely unawares of the history and what had recently happened. I then became aware in April 16.
Okay. Well, I'm going to cover that shortly, so we'll come back to that topic. But before I do, I want to ask you a couple of questions on materiality, which appears in your statement at a few places. Please, could we have up page 6, paragraph 17 of the statement? Thank you. You say at the bottom there that the board will not consider the specifics of individual bugs or defects, which is generally the responsibility of the specialist in the IT team, save to the extent that those bugs or defects have a material impact on the day-to-day running of the company. And then at paragraph 18, you say typically a non-executive board would have high-level oversight of the conduct of any civil litigation brought by or against the company, but only if and when it became material. Each company will have its own materiality threshold, and unless a civil claim met that threshold, I would not necessarily expect the board to be made aware of it or updated on its progress. How was the threshold of materiality determined at the Post Office Board in 2016 to 2019?
In my witness statement comments, I refer to materiality as if it would be determined by the auditors. So the statement would be based on, normally, if I recall correctly, a percentage of turnover. So in this case, my use of the term materiality would be a percentage of turnover of the post office, and that's the reference that I make by materiality. So in the case, if I recall correctly, then it would be many millions, but that's the use of the word materiality.
We've heard this before in the inquiry of exactly the definition you describe, and would you accept that the materiality from the perspective of the Post Office Limited Board would be different from materiality to an individual sub-postmaster?
Yes, I would.
In terms of the allegations that, sorry, before I ask that question, did the board, when you were there, ever consider the Post Office, sub-postmaster's perspective of materiality?
The comment on materiality was driven by the auditor definition, or from an annual accounts perspective. We didn't look at it, as I recall, from a sub-postmaster perspective.
In terms of it, the allegations that were made that Post Office had secured convictions using unsafe convictions using data generated by the Horizon IT system, so the allegation of an unsafe conviction, is that a matter that should be considered at board level, or is there a test of materiality for unsafe convictions?
When I joined the board in January 2016, to the best of my knowledge, there was no convictions, and none of the existing board members at that time had sat on the board previously, and so therefore I find it hard to comment on your question.
Can I just clarify with you what you mean by no convictions there? Do you mean when you were senior independent director, Post Office didn't secure, you believe Post Office didn't pursue prosecutions that led to convictions in that time?
That is my understanding.
Let's look at your appointment letter, please. It's Pol 20362996. So you see it's dated the 2nd of December 2015. And if we could turn to page 8, please. It refers to an induction saying, after the commencement of your appointment, the company will provide a comprehensive, formal and tailored induction. We will arrange for site visits and meetings with senior and middle management. What induction did you actually receive by Post Office?
I met most of the senior executive team face-to-face at Post Office offices.
Can we just so we can be clear, when you say the senior executive team, most of, who are you referring to?
I'm referring to the person that was in charge of the banking business, or the person that was in charge of the mails business, so the people that were leading the various business units of Post Office. I met the Chief Financial Officer. In addition to that, I met the Chief Executive. So I mean the sort of top line executive team. I don't recall how many of the people I met but I met a number of the top line team. After that, I then did some external site visits, and I visited some sub-post offices in the network. If I recall correctly, probably 4 or 5 sub-postmaster network offices.
Did you meet anyone from the legal department as part of your induction?
No, I did not.
So, for example, Jane McLeod, you didn't meet her as part of your induction?
No.
Please, can we bring up your statement, page 33, paragraph 73? You're giving your reflections here, and you say, when I joined Post Office, the board was still relatively new, and to my knowledge, none of the non-executive directors had been in post at the time when the legacy Horizon system was in operation and the private criminal prosecutions were still ongoing. I can recall feeling as though we had been left holding the baby, and we had to decide what to do with it based on our limited background knowledge. What in particular left you feel as if you were holding the baby?
Not having a non-executive on the board who understand what had happened for the previous 1, 2, 3, 4 years, and not having that knowledge.
And when did you get this feeling?
My comments were quite general when I started to find out about the Horizon issues, which was between April and September of 2016, that there was no one when I looked at my colleagues who was in position prior to that.
So reading this, you say the first sentence, when I joined Post Office Limited. The second statement, I say a sentence, sorry, I can recall feeling as though being left holding the baby. Your evidence is that that happened later in April 2016 onwards, rather than when you joined Post Office Limited.
That's correct.
That document can come down, thank you. You refer, we don't need to turn it up, but in your witness statement, you refer to having an interview with Baroness Neville Rolfe prior to your appointment as Senior Independent Director.
Yes, that's correct.
And your evidence is that she didn't discuss with you matters such as the allegations regarding Horizon or Tim Parker's review.
That's correct.
How confident are you, now looking back, that she made no reference to the Parker review in that interview?
Very confident.
Why?
Because I would have remembered something as significant if there was a major issue that had been identified to me at the time before I was likely to join a new board. So I'm as confident as I can be. Bear in mind, I'm talking 8 years ago, that I recall that nothing was mentioned about the historical issues.
Do you remember what briefing material, written material, was provided to you as part of your induction?
No, I don't.
As part of your Rule 9 request, the inquiry sent you a number of documents and asked you when you first had knowledge of them. Can we turn, please, to page 18 of your statement, paragraph 41? You say towards the bottom of that paragraph, oh sorry, I'll wait for you to get on screen. You say towards the bottom of that paragraph, I now realise that by this time, and you're referring to the 30th of October 2018, we see at the top, I now realise by this time several reports have been commissioned by Post Office into possible issues with Horizon, and I have been provided with copies of certain reports dating back to 2013. Except as set out in this statement, I had no knowledge of any report of those reports until they were provided by the inquiry. In that sentence, are you referring to documents such as the second site interim report in 2013, which commented on the it commented on the Horizon system itself?
Yes. The first that I've seen of any reports on the Horizon system were in documentation provided by the inquiry.
Please can we turn to POL 406357. It's a document very well known to the inquiry. It's Simon Clark's advice of the 15th of July 2013. It was sent with the Rule 9 request to you and was one of the documents that the inquiry asked you about. Did you read it when preparing for this statement?
No, I did not, because I wasn't in position in 2013.
So, are you aware of what this document says?
No, I'm not.
If we, firstly, before I ask what it says, when did you first see this document?
Only when it was presented to me as part of the papers from the inquiry.
Why did you not refer to it in your witness statement?
I didn't believe that it was relevant to me on the basis that I wasn't in position and didn't know anything about it. And so therefore I'd struggle to comment on it.
If we turn, please, to page 13. We see under conclusions, it says, what does this all mean? In short, it means that, and it says Dr. Jennings, which refers to Gareth Jenkins. Presumably now you know who Gareth Jenkins is.
Yes, I do.
Gareth Jenkins has not complied with his duties to the court, the prosecution or the defence. And if we go down at 38, we don't need to go through it all, but it says Dr. Jenkins failed to disclose material known to him, but which undermines his expert opinion. This failure is in plain breach of his duty as an expert witness, and continues. Were you provided any information regarding Gareth Jenkins when you joined the Post Office?
I was not.
When was the first time you heard of Gareth Jenkins?
The first time I'd heard about Horizon issues was between April and September 2016, after I joined in the January 2016. I don't recall exactly when I found out about Gareth Jenkins. I don't have a date of recollection in my mind.
Do you recall when you found out about the allegation that Mr. Jenkins had failed to comply with his duties as an expert?
I don't know about duties as an expert, but in terms of ability to access the system, I believe that was in November, December 2019.
When you say ability to access the system, do you mean remote what we now refer to as remote
Yes,
access?
I believe so, yes.
I mean, can you assist us with whether you were aware of concerns about Mr. Jenkins before the, say, the common issues judgment?
No, I was absolutely not.
Again, I'll phrase it slightly wider. When do you recall when the first time you became aware of concerns with Mr. Jenkins within Post Office?
I don't recall an exact date.
Can you give us a brief time period?
Only when I go back to my November, December 2019, when I heard the system could be remotely accessed. That's probably the first time. I don't remember anything prior to that.
Did you discuss concerns about Mr. Jenkins with anyone else on the board?
No, I did not.
Could we look at the monitoring, please, of the group litigation? We don't need to... Actually, no, let's bring it up, please. Your statement, page 16, paragraph 37. You say, initially Ms MacLeod delivered updates to the full board on the status of the GLO proceedings, which soon became a standing agenda item. These updates were necessarily limited to high-level news and headlines, how many claimants had joined the claim, whether there was going to be a class action, and similar key issues and milestones. From a very early stage, there was a huge amount of detail in the GLO proceedings that the board would not have had time to review, and it was not the board's role to do so. Looking at the board minutes I've been provided with by the inquiry, the notes of Ms MacLeod's updates appear quite light. It's not clear to me now why the chairman did not request more detail in the minutes. And you refer to Ms MacLeod's preoccupation with preserving privilege. So just clarifying this, is your evidence that actually, as a matter of fact, Ms MacLeod provided more substantial briefings to the board orally than is reflected in the minutes?
Mrs MacLeod provided updates to the board that were almost verbal, that I recall.
Yes, and when she provided those verbal updates, is your evidence that what she actually said to you when you were in the boardroom was more substantive or provided more information than is reflected in the board minutes?
No, I don't recall specifically because everything was verbal. I find it hard to recall whether it was more detailed or less detailed. I just recall it was a verbal update, and the minutes reflected that update being quite light. I don't know why, but Mrs MacLeod wouldn't present for 1 hour or otherwise. It was a short session that I recall verbally updated on the high-level points of the litigation.
Well, what do you mean by it is not clear to me now why the chairman did not request more detail in the minutes? Are you saying that the chairman should have requested there to be more detail written down as to what Ms MacLeod actually said, or that the chairman should have requested that Ms MacLeod provide more detail to the board?
I'm saying that the chairman should have requested more detail in the minutes.
And so, from your recollection there, in saying that, what do you think is missing? What sort of information is missing from the minutes that has led you to make that statement?
The basis of my comments relate to receiving information from the inquiry. If I was able to read it now, it would give me a better understanding of what was said and what happened during those meetings, if the minutes were more detailed. So my comments are really driven by recollection of memory as opposed to anything else.
Why didn't you raise any concerns about the minutes at the time?
In hindsight, I should have done.
Please can we bring up poll 2424270. So we know and have heard evidence that there was initially a steering group for the GLO, and then the board created a subcommittee in early 2018. In fact, we see it paragraph 2.1. It says it's following the meeting of the 29th of January 2018. In your witness statement, you refer to one of the purposes of the committee to be to receive legal advice. Was it also to provide oversight for how the litigation was being conducted?
If I recall correctly, there is terms of reference. There were a terms of reference of the subcommittee in documents. I haven't seen it as part of my papers, but if I recall, there was terms of reference, and the day-to-day management of the subcommittee and working with the legal officers representing Post Office was the duty of the company secretary or legal team, Jane McLeod, and the executive. Then, after that, if there was anything required to be escalated, then that would be escalated to the subcommittee.
So that can come down for the time being, thank you. What did you see, leaving aside what the formal terms of reference said, as a matter of practice, what did you see your role to be on the subcommittee?
The group litigation, as I first found out about in between April and September 16, started to snowball very quickly. There was approximately 90 claimants, and that snowballed very quickly into 550 or 560 claimants. And so things were moving very fast. And the role of the subcommittee was to be able to try and quickly react if there was any decisions or any advice that was required, because it was happening so fast. Decisions had to be made. And so therefore the purpose, as much as anything, of the subcommittee was to try and assist the board in understanding what was happening and to be available if the executive or Mrs. McLeod had to escalate anything that required further discussion.
And can you give us a summary of what types of things were escalated to the subcommittee?
I don't recall specific documents or items at the moment, and in my papers provided by the inquiry, there wasn't any documents that I can give as an example, but it was more about the frequency and the feed of information that was coming very quickly.
I want to look at a different topic, please, and that's what we now call the Swift Review, or Tim Parker's review. When did you first become aware of Tim Parker's review as commissioned by Baroness Neville-Rolfe?
I never was aware of the Swift review until the papers and I saw the documents provided by the inquiry.
So I want to try to delineate two things here. Firstly, when were you aware that Tim Parker was carrying out a review at the request of Baroness Neville Rolfe?
I wasn't aware at all, and I was never informed of that at all.
And the second question I was going to ask is, when did you become involved with, when did you become aware of Sir Jonathan Swift's involvement? And your evidence is, and you didn't see the report, the advice, until it was sent to you by the inquiry.
That's correct.
Apologies if I've misheard you, but just so I can be clear, that's when you saw the advice produced by Sir Jonathan Swift. When did you become aware of his actual involvement?
His being, can you just clarify?
So I'm very sorry, yes. Sir Jonathan Swift's involvement.
The name Swift I was not aware of. It's not a name that I was aware of. I believe when I looked through the papers provided by the inquiry, there's a comment from Tom Cooper which says, I attach, and I don't believe he names anything, but he attaches a document. I don't recall ever receiving that or seeing that document, but I've read the papers provided by the inquiry, but to the best of my recollection, it doesn't mention a name, and I don't remember seeing it. So physically seeing what was the Swift report and the letter to Baroness Neville Rolfe, I didn't see it until it was provided by the inquiry.
I want to bring up, please, Jay McLeod's witness statement. It's WITN 1001010. This is a witness statement provided to the inquiry by Jay McLeod, dated the 30th of April 2024, which has been read into the record. Can we please turn to page 101? And if we could go down, please. No, sorry, it should be starting at page 100, paragraph 184. So we see at the top there, referring to 183, Sir Jonathan Swift providing a draft version of his findings to Mr. Parker. At 184, Jay McLeod says that I have not been provided with the minutes of any board meetings or group executive meetings in which the chairman's review or the findings from it were discussed. Although it is clear that the board were aware that it had been commissioned, as the CEO informed the board at its meeting on 22nd of September 2015, pausing there, that's before you joined the post office, that the minister had asked the chairman for his independent review of Sparrow. It then goes on, if you see further down, it says, it refers to Mr. Parker's comments in open source material. He says, my recollection is different to Mr. Parker's, although I agree that I discussed privilege and confidentiality with him when I met him. My recollection is that the senior independent director, Mr. McCall, asked a question at a board meeting as to whether the board would be briefed on the findings of the chairman's review, although I do not now recall the exact timing, but it was after the further work recommended by the chairman's review had commenced. Pausing there, do you recall asking such a question as indicated by Mrs. McLeod here?
No, I don't.
So, in your evidence, where we saw you refer to feeling being left holding the baby, you weren't referring to learning of the chairman's review?
I have not seen that document, nor have I questioned it, nor have I said I have a totally different recollection. Otherwise, I would have not have made the comments in my witness statement.
I'm just going to continue with what she says, in fairness to you, so it's put to you. I believe that as a result of that question, so this is Jay McLeod speaking, I provided an oral briefing to the board, although I do not recall if this was at the same meeting or subsequently, as to the scope and findings of the Chairman's review, as well as a summary of the further work being undertaken following the Chairman's review. Again, I'll put it to you. Do you disagree then with Ms McLeod's recollection?
I have absolutely an alternative view on that. I have never, and I stress again, I have never seen that report, nor do I recall in any way that I made those statements or that word.
And finally, she says, although I have not seen the documents which indicate that the full report was circulated to the board, my recollection is that I advised the board that the full report was available on request. Do you agree with that?
No, I do not.
That can come down, thank you. Could we please bring up poll 30024913? It's a letter from Tim Parker to Baroness Neville Rolfe regarding the his reviews dated the 4th of March 2016. I think you've already referred to it, but for clarity I will ask, did you see this at the time?
No, I did not.
When was the first time you became aware of this letter?
In the papers provided to me by the inquiry.
Could we turn please to page 2? And if we go down to the criminal prosecution section, we don't need to read it all. It sets out some information on the review and the criminal prosecutions element of it. And one, it says, well, above one, it says, as a result of the review, I have decided to take the following steps. It says, I will take advice from specialist criminal counsel as to whether the decision to charge theft and false accounting could undermine the safety of any conviction for false accounting if A, the conviction was on the basis of a guilty plea following which and or in return for which the theft charge was dropped, and B, there had not been a sufficient evidential basis to bring the theft charge. Were you aware of that work described there having been commissioned?
No, I was not.
Do you think you should have been made aware of that?
My first board meeting was in February 16, and I noticed from seeing the letter again, it's March. But yes, naturally, in the course of events, I believe I should have been aware of it, but I was not aware of the letter at all.
If we turn the page, please, page 3. There's information on Horizon, and it refers to, firstly, various bugs, errors and defects. We don't need to go to that. It's the second 2 paragraphs I want to refer to. Nevertheless, the report suggested that consideration should be given to whether it would be possible, by analysis of the transaction logs of sub-postmasters who made complaints, to determine more comprehensively whether or not the matters complained of by each sub-postmaster could show the existence of some other generic bug within the system. Work is now underway to assess if such testing is possible, and if so, to scope the work that would need to be done. And then it goes on to say, further work is also underway to address suggestions that branch accounts might have been remotely altered without complainant's knowledge. Were you aware of one or either of those recommendations or work being carried out further to them?
No, I was not.
That can come down, thank you. Can we bring up UKGI 30122703? It's an email from Tom Cooper on the 16th of September 2020. We see in the distribution list and the CC list there are various senior figures at UKGI and then what was Bayes, the Permanent Secretary included. He says, ahead of our call this afternoon, this is just to update you that Ken McCall, the Senior Independent Director, has confirmed that, having spoken to other members of the board as he deemed appropriate, he does not think it appropriate to take action in relation to Tim Parker's decision-making around the QC's review in 2015, referring to the SWIFT review, of Post Office's handling of the Horizon complaints. His rationale is the same as reported previously. Ken believes Tim made a significant error of judgment in accepting legal advice at the QC's report and, as a consequence of the follow-up work, should not be shared with the board. Does that fairly summarise any work you carried out following your discovery of the Chairman's review?
The Chairman's review, and you're talking the Chairman's, just for clarity, you're talking the Chairman's review of performance.
Well, initially I'm saying once you were asked to conduct a... Well, no, let's pause here. This says that he does not think it appropriate to take any action in relation to Tim Parker's decision-making around the QC's review in 2015 of Post Office Limited's handling of the Horizon complaints. And then it goes on to say that you believed that he made a significant error of judgment in accepting legal advice that the QC's report, namely Jonathan Swift's report, and as a consequence, the follow-up work should not be shared with the board. Will this suggest that by September 2020 you were aware of the Swift review?
No, because by name I wasn't aware what anything was called. Just for clarity, I don't recall the term Swift, and I don't see it in this document, and I've not seen it in anything that's been provided to me that would indicate, better than my recollection, that I have seen, and this refers to the Swift report. So my understanding is that the Chairman conducted a review. I did not know what it was called or what it was, and it wasn't shared with the board. But the name of Swift was not known to me.
Were you aware that he had instructed a barrister to assist with the review?
No, I was not.
So is your evidence that Tom Cooper here, when saying Ken believes Tim made a significant error of judgment in accepting legal advice that the QC's report and, as a consequence, the follow-up work should not be shared with the board, your evidence is that's inaccurate?
My evidence is that if there was something as serious as that having taken place, then I believe the Chairman should have shared it with the board.
That's a separate question. I'm asking, on this email from Tom Cooper, the suggestion is that you had evaluated Mr. Parker's performance and determined he'd made a significant error of judgment in failing to share legal advice that in the form of what's described as the QC's report, and failing to share that with the board. Is that wrong?
My conversation with Tom Cooper, to the best of my recollection, there wasn't a reference in our conversation to QC. So therefore, I just recall Tom saying, Tim Parker has carried out a review. It's not been shared by the board. I don't recall there being a name given to that document or QC's document. And the email here is much more direct than the conversation that we had. So my conversation with Tom Cooper was, apparently there's been a document that Tim has commissioned, and it's not been shared by the board. It was his general as a recollection as that I have. So here it's very specific. It says in this email, which obviously I'm not a party to and didn't see, then you know, it's a much more strongly worded than the phone conversation with Tom Cooper with me was.
Did you say to Tom Cooper that you thought, on the information you had, that Tim Parker had made a significant error of judgment?
If there's a major report that the chairman should have shared with the board, then that's why I would refer to it as a significant error of judgment.
So in saying you would have referred to it as a significant error of judgment, you said if there was a major report. What were you told for you to believe there was a major report that he'd failed to share with the board?
Verbally from Tom Cooper.
And what did he say specifically about that report?
I mean, we're talking 4 years ago or thereabouts. I don't specifically recall the exact conversation, but the chairman had commissioned a report and it's not been shared with the board. That is the essence of the conversation. There was no reference to SWIFT, there was no reference to QC, and so I don't understand how Tom knows those factors or QC's report. I certainly didn't know those factors.
Have I got this right, Mr. McCall, that you accept that there was a conversation with Mr. Cooper either shortly before or on the date of this email? In that conversation, he told you that Mr. Parker had received a report which had not been shared with the board. You were told enough to consider that that was a significant error of judgment on the part of Mr. Parker, but given his overall record, you did not think that any action should be taken against him in respect of that error of judgment. You, however, dispute the fact that you were aware either of the name SWIFT or that the report was carried out by a barrister. Now, is that a fair summary of what you've been debating with Mr. Stevens?
Yes, sir. That's correct, sir.
Fine. Thank you.
Please could we bring up UKGI 30122155? I think this is a document you were referring to earlier. We see it says from Tom Cooper at the top. 2 includes Tim Parker, and you're there as well, Ken McCall. Subject Chairman's Review Report. Attachment QC Post Office Review, 7th Feb 2016, and then also the letter to Baroness Neville Rolfe, dated 4th March 2016. As promised yesterday, please find attached a copy of the QC's report prepared for Tim in 2016. The recommendations are at the back. I also attaching a copy of Tim's letter to the Minister. Do you accept you did receive the SWIFT review?
No, I do not. I accept I saw in the documents provided to me that this is exactly what it says, but I have no recollection of actually having seen that report.
Is it not the case that you, on the 30th of July 2020, received the SWIFT review, and then later, in the email we just went to, gave Tom Cooper your views on it, namely, having read the report, you thought that it should have been disclosed to the board?
I don't believe so. To the best of my recollection, I believe I would remember or have remembered if I saw a document such as this.
So that's probably a good time to take our break, and I wonder if we could come back at 25 past.
Yes, that's fine, Mr. Stevens. I was just checking the time. Yeah.
Thank you, sir. Can you still see and hear us?
Yes, thank you.
Please could we bring up poll 204104-107. So we see this is an email from you to Veronica Branton and others on the board on the 22nd of April 2020. We'll come to it in a moment. You say, I would appreciate seeing a redraft of the minutes to include the points raised by Tom. And that's an email from Tom Cooper, to which we'll turn in a moment. Before we do, he says, I must say at this stage, I do not feel comfortable that the minutes truly reflect the complete unawareness of the board to the existence of a Deloitte report, whom it was commissioned by, and the contents therein, and that the minutes reflect the complete shock at finding out that Fujitsu had remote access. Now, pausing there, the inquiry has sent you two sets of, well, several reports from Deloitte, but in two sets broadly. One, Project Zebra from 2014, and one, Project Bramble from 2016 onwards. When you say the existence of a Deloitte report, to what are you referring?
I wasn't aware, if I recall correctly, that there was more than one, so I don't have a name or a badge that I can give to that report. I didn't know that there was multiple Deloitte reports. Only in the papers that were sent to me by the inquiry was I aware that there was multiple Deloitte documents.
So is your evidence you were, at this point, you were aware of no Deloitte reports regarding remote access?
That's correct.
And when you say things like complete shock and complete unawareness, do we take from that that you think the Deloitte report should have been before the board?
That was my perception, that someone had commissioned a report and the board hasn't seen it.
So did you think it was an important report?
That was my perception at the time, that there was a report and that the board should have seen it. And so my words used then are complete unawareness by the board. And I believe myself and my fellow colleagues on the board, specifically I refer to the non-executives, would have felt the same way.
So if you'd known earlier that there was a report by Deloitte that dealt with remote access, would you have wanted to know more about it?
Yes, I would.
Could we go, before we move on to look at that in more detail, I want to look at Tom Cooper's email, which you referred to there. So as I say, you say, I would appreciate seeing a redraft of the minutes to include the points raised by Tom. If you could go to the bottom of the page. See, that is the email from Tom Cooper. You are sent it, we can see on the right side. And then if we go to see the meeting, it says, Veronica, I've got a few points on the minutes from the last meeting. Something at paragraph 7 about the Deloitte report. He says, I'd like to clarify that the who knew about question should apply to the various pieces of work commissioned. And you see the third one is following the Jonathan Swift QC report. So you were aware that it was Jonathan Swift QC who prepared a report by at least the 22nd of April 2020. Would you accept that?
I accept it when I see it here in email, but day to day, I don't have any recollection of that specific email, and I don't have a recollection of the name. But there is an email here which I read the title and I see it and I accept, but it's not something that I had any retention for.
Looking back now then, would you accept that firstly you knew Jonathan Swift had commissioned a report, it was later sent to you, to Tim Parker should have disclosed it to the board?
I see the paper trail in the email trail. I have no recollection of receiving the Jonathan Swift report. I have none at all.
So are there two options really? One is your recollection's inaccurate and you did receive it and read it. Or secondly, an obviously important report that you were sent, you didn't open.
The former, in that I have no recollection of receiving the Swift report.
Actually, the former thing I said is that your recollection is incorrect.
Yes.
Are you accepting your recollection is incorrect?
When I see the paper trail, you would have to say, yes, that's potentially the case.
That document can come down, please. Could we please look at your statement, page 29, paragraph 63? You say at some point during the board's review of CCRC cases, I received a telephone call from Mr. Cooper regarding a Deloitte report that Mr. Parker appeared to have commissioned but had not shared with the board. And you go on in that paragraph to say you believe now that he was referring to Project Bramble, which, as I said earlier, was the post-2016 work. If you can turn the page, please, to paragraph 66. You say, during the CCRC review meeting, which Mr. Parker attended, the board raised the subject of the Deloitte review and why it had not been shared. The tone of the meeting was not one of anger, but definitely puzzlement. And said Mr. Parker's explanation was that he had been advised that the report was legally privileged and should not be shared with the board. So your evidence appears to be you were told of the Deloitte review, the report, and you attended a board meeting at which you asked Mr. Parker why he didn't provide that information earlier.
Yes, that's correct.
Please could we look at poll 406753. These are minutes of the group litigation subcommittee of Post Office on the 21st of February 2019. We see Tim Parker attends by phone, and then third down, you attend by phone as well. Yes?
Yes.
And we also see that Anthony Degar Robinson, QC, as he then was, gave, if we go down please, the upcoming Horizon trial, gave a briefing or an advice in conference on his views. If we turn the page, please. Number 4 says remote access risk. The claimants have posited the theory that Fujitsu had interfered with branch data in secret. Post Office Limited and Fujitsu's case on remote access had changed over time. Initially, Fujitsu had said that remote access was not possible. The Deloitte audit had found that it was. The claimant's expert was arguing that the scope for remote access was even greater than now stated, and it goes on to say what the court would do. So let's take it in stages. Firstly, you were aware at this stage, weren't you, that remote access by Fujitsu was possible?
My recollection was sometime between November and December 2019.
That's your recollection, but this is a minute from February 2019 at which remote access is discussed. So do you accept that you were aware of remote access by at least this date in February 2019?
From the minute that's in here, I have to accept that that's the case and my recollection's wrong.
And secondly, it refers to the Deloitte audit. So you were aware of Deloitte's involvement in an issue relating to remote access. Would you accept that?
Yes, I do.
If we look further down, please, we see questions. And the first one is about optimism on the claim. There's a note, the second, a note about a limit to planning that we could do before we had the judgment in the common issues trial. And a discussion there about risk mitigation. If we turn the page, please. It says there in this paragraph, whether an accusation was being made that Post Office Limited had been involved in instructing Fujitsu to change transactions, it was noted that only Fujitsu could change data, and there was no suggestion that Post Office had operated a policy to get Fujitsu to manipulate the branch data. The claim was that we had lied about Fujitsu's ability to change branch data. It was noted that it was hard to capture the number of instances in which data had been changed, especially in the legacy Horizon system, because of the way that data was captured. We could not distinguish easily between maintenance access and making changes to branch data. However, Fujitsu had been clear that branch data had only been changed on very rare occasions. And then we see it goes on to say about a line between bugs and systemic system errors and appeals. So from these minutes, it firstly doesn't appear that any surprise was raised at this information that Fujitsu could remotely access data. Do you accept that?
I do.
And secondly, there's no questioning raised such as, what is the Deloitte audit? Would you agree with that?
I don't see anything of that in the minutes.
From that, can we infer that members of this committee were aware of the Deloitte audit before this meeting?
According to the minutes, I would have to agree with you, but as I say, the dates were not my recollection, but I'm obviously incorrect.
So you can't assist us then. You've said in your evidence it's November 2019 or maybe December 2019. Looking at this document, you can't assist with when, before February 2019, you may have found out about this information.
It's in my witness statement, I've honestly, to the best of my recollection, said this is the date I believed I found out about remote access, and that's what's in my statement, that's what I believe. But you've obviously shown me something that where my recollection is incorrect.
Do you recall reading any of the reports into the Deloitte, the Bramble Deloitte report?
No.
Given what we said earlier about the significance of this, and you would have asked about the Deloitte reports, if you were aware of it, of the Deloitte reports at this time, would you have asked to read them?
Yes. I believe it was an error, certainly on my behalf.
Sorry, you say you believe it was an error. What are you referring to there?
I believe if I had been aware of the Deloitte reports, I should have asked to see them.
Can we look, please, at a different topic? It's your approach to the litigation. Poll 406380, please. Now, This is a paper for the steering group on the 11th of September 2017, the group litigation steering group. You weren't a member of that steering group, were you?
I was not.
You only became involved when it was the subcommittee, the board subcommittee.
That's correct.
We see it says the title is Does Post Office Support the General Strategy Set Out Below? Do you recall whether you saw this document as part of your role as a senior independent director at the time?
No, I have not seen the document.
If you turn please to page 2, paragraph 4.3. We see the heading is overall post office strategy, and there's some discussion on that, and then we get to 4.3, which says we believe the better solution is to try to force the claimants into a collective position where they will either abandon the claims or seek a reasonable settlement. So I'm to refer to the litigation funder, and at the end says, our target audience is therefore frees the funder and the insurers who will adopt a cold, logical assessment of whether they will get a payout, rather than the claimants who may wish to fight on principle regardless of merits. So to try to force the claimants into a position where they give up or settle, we recommend a three-pronged approach, which we don't need to turn to. Were you aware of that broad strategy of trying to force the claimants into a position where they give up or settle and focusing on the solicitors, funders and insurers?
No, I was not.
In your witness statement at paragraph 36, we don't need to bring it up, you say that you recall the board being advised that the claim was funded by a litigation funder and that their model would be to move quickly to get other claimants involved.
Yes, that's correct.
Can you recall the context in which you were told that there was a litigation funder involved and the purpose for why you were told that?
It was just a matter of fact. When the discussion came forward about who was representing the claimants. So it was only used as a matter of fact, a matter of information.
Could we look please at poll 20258-369? Sorry, bear with me. Please, could we go to page 2? And further down, please, to Jane McLeod's email. Thank you. Refers to the case management conference last week and the decision of then Mr Justice Fraser on the strikeout application on striking out parts of the witness evidence that the claimants had filed. At the bottom we see it says, however, in deciding the application, the managing judge was very critical of our conduct of the case, intimating that we were not acting cooperatively and constructively in trying to resolve this litigation, which criticism was levelled equally between the parties, and that we had impugned the court and its processes by making the application for improper purposes. The response is extremely disappointing, as this has not been our intention, and his challenges to the purpose for which we had applied for strikeout is at odds with comments he had made during various procedural hearings over the past year. If we go up, please, to page 2 to see Mr McCall's response. Jane, many thanks for your note. Disappointing indeed. I would like to suggest we have a full update the next time we're all together, and say you leave it to Tim for thoughts on the discussion. What, if any, action did you take in response to learning about Mr Justice Fraser's criticisms of the way the Post Office had handled the litigation?
I believe, if my recollection is correct, that's when we changed QC's now KC.
No, this is before. So this is before the Common Issues trial.
Oh, I see. Then my view would be the tone and the approach that we took.
And what did you do to address the tone and the approach?
I personally don't recall, I don't recall specific conversations other than I've said, look, I think we need to discuss this, and I think we need the chairman to lead a discussion on what actions we should take. That was the purpose of my note.
That can come down, thank you. I want to go to a different topic, please, on contingency planning following in the run-up to the Common Issues trial. Please, can we bring up page 20 of your statement, paragraph 43? You say, I can recall being shocked at losing so badly when the advice from post officers' barristers had consistently been that we had the better of the arguments on most of the 23 separate issues under consideration. Against that very clear and confident advice, it was almost inconceivable that we had lost on all material points. I also did not appreciate, and I do not believe the board as a whole appreciated, how great an impact the Common Issues trial could have on Post Office Limited's day-to-day operations. The words you use there, better of the arguments, is taken from, or at least it's in minutes, recording legal advice was given. When you hear the words better of the arguments, how much confidence do you think the legal professionals had in the case when if using the term better of the arguments?
It's very difficult for me to comment on the legal professionals. My perception on the receiving end of those comments would be that we were in a strong position.
And when you say a strong position, if you were to put a percentage on it, what were you thinking of your chances of success?
Better than 50%.
As in anywhere from 51% upwards, or?
I think it's quite subjective to put a figure on it, but I would say consistently our legal advice had been that our arguments were strong, and that based on those arguments, my perception, and hence the use of my words, that I was shocked. I was shocked. I completely didn't expect what had happened. And so on that basis, I said, well, wow, how can we have got it so wrong? How can that be so wrong? How could this have happened based on our legal advice? And that's what I depended upon.
But from what you're saying, is it fair to say you hadn't considered this to be a certain victory, or had you considered it to be a certain victory?
No, I don't think you can ever say anything's a certain victory, but I certainly believed that there would be a better outcome than there ended up being.
Can we look, please, at poll 406754? So this is minutes of the meeting of the Sub-Postmaster Litigation Subcommittee. We see it's on the 15th of May 2018. At the bottom, we see that you've given your apologies. Would you have read the minutes of the meeting that were prepared when you were in readiness for the next meeting?
I think you would have to assume normally yes, but it's difficult to recall back in 2018.
We see Anthony Degar Robinson QC, and David Cavender QC are listed as in attendance, and page 1, If we go down, please. This gives an overview of the litigation. It says work out in common issues trial, should be trial, what the contract means. Phase 2, work out what the computer system worked. The next paragraph down, CI trial, common issues trial. What king of relationship those documents in the round constitute. We say business to business, but could be interpreted differently. Not straightforward because of the drafting, should be of the contracts, especially should be the older ones. I think actually when I say what king, that should be what kind, I think. Idea of good faith into contracts, especially relational contracts. We assume that's especially long-term arrangements. New law, unclear what a general duty of good faith would mean. And if we, it's there on screen, sorry. Overall view is that the Post Office has the better of the arguments in most 23 arguments. Don't think it likely that the good faith claim will be upheld, but it is material, there for him to do so, brackets, bit of a one-sided contract, etc. But in that case would advise Post Office to appeal. And then if we go to page 4, please. Is there any view on how many of the 23 claims they're likely to win? 5 or 6 significant issues where it's not straightforward, brackets, go away and provide a summary, question mark. Need to manage the comms angle and work out the implications. Do a piece of work on impact of losing any of the 23 terms, aiming to bring this back in about July, looking at mitigations and what we could do now, in addition to what I think we do if we did lose. Interesting to hear QC's view on most contention of the 23 issues. Do you recall discussing the advice with anyone who attended this meeting afterwards?
No, I do not.
Would you accept that it appears that the barristers that were advising that some of the issues were not straightforward?
When I read this document, even though the quality of the English is extremely poor, I'd have to say, yes, there are obviously issues that are not straightforward.
And that the Post Office may lose some of them?
Yes.
And it appears that the committee asked for more work to be done to analyse the impact of a negative outcome?
Yes.
Can we look, please, at poll 406763? This is the meeting of the litigation subcommittee on the 10th of July 2018. We see that you're in attendance on the third line. If you go to page 2, please, towards the bottom, we've got contingency planning. It was noted that the QCs had presented their opinion on the merits of the case at the last meeting, and I concluded that, based on the information available to them at the time, on balance, Post Office had the better arguments. In order to understand the potential impact of an adverse outcome, the various terms sought by the claimants to be implied into the postmaster contract had been assessed from both a legal likelihood and an operational impact perspective, and had been prioritised using a simple RAG approach. These were discussed with the committee, and it was noted that, in general, those terms which had been assessed as the most likely, in fact, had a low operational impact, and conversely, those with the greatest potential impact were less likely to be successful. And it goes on to say over the page that the committee noted that the assessment was very helpful. If we look at that assessment now, it's poll 302598, please. we can see it says draft contingency planning risk assessment table, and do you see the date is the 9th of July 2018 at the bottom left. Do you remember reviewing this document?
No, I don't recall seeing the document.
Do you accept this would likely have been the document that was before the committee?
It's very hard to say, and I don't recall seeing the document. And my solicitors actually asked from my feedback of reading the document, could we please have some more information on the document? Who sent it? What was it produced for? Who was it from? Who was it to? Who was it circulated to? And without that, it's very hard for me to understand. But reading it now, I don't recall seeing the document.
Well, I'm going to ask you some questions on it, and we'll just assist us as best you can. We see at the top, it says this document summarises in Council's opinion on the common issues. By its very nature, it is simplistic and should not be relied upon in lieu of a careful reading of Council's opinion. Where we have offered a view on the impact on Post Office, this is an initial view based on our current knowledge, and we have not sought to set out an exhaustive list of impacts. And then we see below that there's a RAG analysis or a grading table, and we see on the left its likelihood of red 5 being very likely to lose, right through to 1, Post Office is very likely to win the issue. And on impact, 5, a significant adverse impact on the business, right through to there will be negligible impact on the business. And if we just go through that, for example, page 3, if you go further down, please. Thank you. You see there implied term with a high likelihood 5 because it's been admitted, but low operational impact of 2 for cooperation. Over the page, please. Similar on exercise of powers. But if we go, please, to page 7. We see there at 11, there's an implied term about the relationship. And, for example, Post Office would not take steps which would undermine the relationship of trust and confidence between it and the sub-postmasters. And the operational impact has been listed as 4. Over the page, shortfalls. Implied term, Post Office would A, produce, keep and maintain accurate records of all transactions carried out using Horizon, B, be able to explain all relevant transactions, and C, use the records to explain any shortfalls. It's an example of 5 on the operational impact. So looking at that table again, do you agree that you were made aware, as a member of the Postmaster Litigations Board subcommittee, that there were a number of substantial adverse impacts on Post Office's day-to-day business operations in the event that the court disagreed with Post Office's interpretation of the contractual clauses?
In reading the document, yes, I understand it, but my response to you would be that I hadn't seen and I don't recall having seen the document, because I see no information that I've seen it or circulated to me, and I have no recollection of it.
I want to then move to your reaction to the judgment in common issues, please. It's Poll 2039264. This is an email from you to Tim Parker on the 13th of March 2019, so shortly after the judgment in common issues. It says, Tim, apologies I was not able to stay on the call longer. Anyway, I understand we have a further call week of 18th to be scheduled. Outside of the call, I assume that's would appreciate a private conversation with you on this topic. Pausing there, we see the subject says GLO call. And it would be great if you could let me know what might suit. Can you recall what your private conversation with... Well, firstly, can you recall if you had a private conversation with Tim Parker following this email?
I don't recall specifically, no.
Well, do you recall what type of things you discussed with Tim Parker in private conversations following the GLO judgment in common issues?
I have no recollection. I mean, we're talking March 19. I think to remember a conversation is extremely hard, so I don't have a recollection of it.
This was a pretty significant moment, wasn't it, for the Post Office?
Yes, indeed.
And is it fair to say you can remember your reaction to learning of the decision in common issues?
Yes.
So can you not remember, is your evidence you can't remember discussions you had in private with Tim Parker about that very issue?
I don't remember having a discussion in private with Tim Parker.
I want to briefly touch on the recusal application, please. Can we bring up your statement, page 24, paragraph 50? You refer to a debate and the board unanimously supported the recusal application, including Tim Franklin. You said no one on the board, to your knowledge, had been in that situation before. And the final sentence is, given the rock-solid advice from Lord Newberger and Lord Grabbanner that Post Office had no alternative other than applying to recuse Judge Fraser, recusal appeared to be the only logical way forward. Can you explain what you mean when you say no alternative? Why did you think there was no alternative?
Those were, because this was such a dramatic situation, I personally, and I believe my colleagues, had never been in a situation like this before. And the reason I remember those words is because those were the specific words that Lord Grabbanner used. And that's why I remember it. I remember those words specifically. If there's anything I remember, it's those words. We had no alternative but to ask to recuse Justice Fraser.
And can you, when saying there was no alternative, can you recall what Lord Grabbanner said as to the reasons why there was no alternative?
There was a number of reasons in the discussion. There wasn't any alternative put forward, but there were a number of reasons. Reliability, credibility of Post Office witnesses, the accusation of inadmissible evidence, small issues being spread across the whole of Post Office, etc. There was a number of reasons and rationale why that apparently, according to our legal advice, amounted to apparent bias. And on that basis, that was the legal advice we were given.
So those are reasons why the application may or may not be strong or may not have merit. Slightly different question is the reasons given for why there was no alternative to make the application.
I don't specifically remember a discussion taking place that pointed out, here are three alternatives, or here is an approach. I don't believe there was that discussion. I believe there was a discussion about the rationale, as I've just explained. But other than that, there wasn't presented a case that said there's option A, option B, option C. We weren't given that.
Well, presumably you knew there was option A, make the application, option B, don't make the application.
That's correct.
So in those circumstances, can you recall what was said for the reasons what Lord Grabiner gave for saying there was no alternative but to go for option A to make the application?
I can't remember his specific words, but as a layman, it's very difficult when we've got some of the strongest possible legal advice, when we have some of the most senior people in the legal profession giving us that advice, and none of the board had the experience of having been through this before, then it was our opinion that we had to follow our legal advice. In hindsight, maybe we should have been far more questioning and said, what are our alternatives? But I don't remember being presented with any at the time.
In your statement, you refer to Tom Cooper recusing himself from the vote on the recusal application. Now, in the board meetings, can you remember Tom Cooper expressing a view on the application?
I remember that in speaking, I remember, first of all, the chairman recused himself because of an existing accountability. And then, I don't remember the exact time, either just before or the day before Tom Cooper recused himself. But it was my clear understanding that there was a unanimous opinion that we should proceed with recusal. I don't recall in any way, I have no recollection of any dissenting word that said no.
Did you have a view on Mr. Cooper's decision not to participate in the vote?
I had to respect his opinion.
You can respect someone's opinion and agree or disagree with it. Did you have a view on whether you agreed or disagreed with his decision to recuse himself?
I understood his position, but I was a little bit surprised.
Why?
I understood our chairman had a conflict which was very evident, but I wasn't sure what the conflict was in the case of Mr. Cooper.
Can we look at your statement, please? Page 25, paragraph 52. Turning down to the preparation for the Horizon Issues trial. Sorry, it's actually page, I'm not sure what I said, but it's page 25, please. You're speaking actually post-Horizon Issues trial. You say, I do not recall that losing the Horizon Issues trial came as a surprise to myself or the board. In contrast to the Common Issues trial judgment, the legal advice we received before the Horizon Issues trial judgment was much more pessimistic, given that we had lost the recusal application. It was clear Judge Fraser had a strong view, and for the reasons we applied to recuse him, and for the same reasons we applied to recuse him, such as his criticism of Paul's witnesses, we did not expect his findings in the Horizon Issue trial to be favourable to us. So I think what you're saying is the legal advice changed after the recusal application failed on Horizon Issues. Is that right?
I would say the legal advice we were given became far more balanced as opposed to convincing that Post Office had a strong case.
So you referred to losing the recusal application, and you say about Judge Fraser's strong view. Are you saying that before Horizon Issues, but after the recusal judgment, you thought that Mr. Justice Fraser would find against Post Office because you believed he developed strongly critical views of the Post Office?
One of the key points put forward in our advice on recusal was his strong criticism of Post Office's witnesses. And on that basis, if those same witnesses were the witnesses in the Horizon trial, there was a strong belief that the arguments of Post Office would not be favourable to securing a judgment.
So at this point, did you think that you were predicting losing the Horizon Issues trial because of the judge's approach to the Post Office witnesses rather than the substance of the matters themselves?
I think it's very difficult to talk about the substance of the matters itself, because obviously myself and none of my non-executive colleagues were employed by Post Office at the time the historical or the legacy Horizon systems were in place. So my knowledge of those legacy systems is very limited indeed. My position here is that I said our inability to have Judge Fraser recuse himself was, in simple terms, due to 3 or 4 factors which would not stand us in good stead in the Horizon judgment.
Well, let's take one of those factors. You said the views you took of the Post Office witnesses. That was one of the grounds, I understand, you took into account when deciding to issue an application to recuse Mr. Justice Fraser, yes?
Yes.
And so you presumably believed that the strong view Mr. Justice Fraser had taken on some of the witness was a ground for arguing that he was apparently biased against the Post Office.
That was our legal advice.
Well, did you believe it?
I believed the legal advice.
Or did you believe or did you agree with the underlying proposition?
I believed that that was a factor, but it was based on the legal advice that we had been given.
So when you're now thinking about the Horizon Issues trial and saying, well, we think our prospects of success are low because of the strong views Mr. Justice Fraser had taken, what did you think of the fairness of that?
I find it very hard to comment on the fairness. What I feel more comfortable commenting on was our legal advice gave a number of reasons, apparent bias.
Ms. McCall, sorry, I interrupted you.
Sorry. And on that basis, given a collection of issues as opposed to just one issue on its own, we voted unanimously to proceed with the recusal application.
Mr. McCall, the point I'm trying to get at is whether you, as the senior independent director, and your view of the outcome of the Horizon Issues trial, whether you thought or believed that it was because there was a lack of robustness with Legacy Horizon as a matter of fact, or whether it was because you thought that the judge had taken strongly against your witnesses and it was just the outcome of a trial.
I think my knowledge, as I said earlier, my knowledge of the robustness of the Legacy Horizon system was very limited. I wasn't at Post Office. I had no knowledge of that system whatsoever. But the judgment that you're asking me on, I believe that the judgment was given on the basis of the Legacy Horizon system was not robust.
I want to look at now some of the issues after the judgment and the steps that Post Office took in response. Can we look at, please, Poll 3021586? It's a Post Office Board meeting on the 30th of June 2020. And we see you're there on the third line down. Could we please turn to page 5? We have postmaster engagement / representation. It says, Nick Reed explained that we were trying to rebalance the relationship between Post Office and postmasters, recognising the historical position in the GLO. The partnership during COVID-19 situation had been very positive and built up trust. We wanted to forge a proper partnership and make running a post office as an attractive proposition. It goes on to describe some road shows. The second paragraph says, Amanda Jones noted that the position had been moving quickly and the conversation with the non-executive directors and UKGI had been very helpful. We had taken on the suggestion to extend the consultation period, etc. Do you remember the conversations you had with Amanda Jones at this stage regarding postmaster engagement?
Not the specific conversations. I remember that Nick Reed carrying out roadshows to try and rebuild trust, to listen to sub-postmasters, to try and connect exactly with those people that were part of our network and that were running the most important part of our network. And so I remember the roadshows. I remember that the attendance was very good. I don't remember specific details. I think there was 4 or 5 or maybe half a dozen roadshows, and the information that came back was that they were welcomed, they were very positive, and they provided good feedback.
If we look at the bottom of the page, please. There's a bullet point. It says, Tom Cooper noted that it was important to establish the board was comfortable with the proposals to include one or more postmasters on the board. All of the directors confirmed that they were comfortable with the proposal and would prefer that 2 postmasters were appointed to the board. It goes on to say they should be non-executive directors and remunerated as such. And then at the bottom, it says, as noted, we would need to think carefully about the selection process and also the credibility of the appointees with their constituency. Can you recall the discussion on the selection process and credibility of appointees at this board meeting?
I can't recall the specific discussion. What I do recall is that we were very keen to ensure that the sub-postmasters joining the board were recruited and independent. So therefore, it wasn't the post office choosing 2 people. It was actually the postmasters themselves choosing who the representatives would be. I remember that was the principle of independence, and the sub-postmaster should have the ability to do that. That's my recollection.
Were you involved in establishing or advising on establishing how the appointees would be selected?
I don't recall that I was.
That can come down, thank you. I want to ask you some broader questions which touch on the next phase that the inquiry is going into, phase 7. Aside from the what we've just referred to there, the sub-postmasters on the board, what are the steps had the Post Office Board taken following Horizon issues to try to address the culture of the organisation and the criticisms made by Mr Justice Fraser?
There were a number of work streams instituted to try and improve the relationship. There was technology such as the branch hub system, which was to try and address the speed, the feedback, the ability of sub-postmasters to go online and address any challenges or queries they had themselves, the ability of Post Office through that branch hub network to be able to communicate far faster and far more quickly to sub-postmasters. There was a strong push to try and improve the communication, in addition to having 2 sub-postmasters on the board to help advise, guide and give the board confidence that the sub-postmasters were being represented in terms of strategy, communication and support. So there was a much stronger push to get a lot closer to the network and the people through some of these initiatives.
And as at the time you left, which was January 2022, what did you think of the adequacy of those measures in practice?
My recollection is that we had high 80s, maybe 90% of the branch network connected and working with Branch Hub. The 2 sub-postmasters were an excellent addition to the board and gave really good, strong, at times, and honest communication and feedback. And I thought they were doing an exceptionally good job in representing the sub-postmasters. And I felt Nick Reid was really strongly trying to get as close as possible to the sub-postmasters and improve the relationship between Post Office executive and the network. So I felt that the moves that were made were very positive.
What was the culture of the board like at the time you left?
I left in January 22. Myself and my colleagues who were there tried our hardest to address the historical issues and to, in some small ways, try to put right what had gone wrong, as none of us had been in position at the time. And so the culture was one of trying to help, trying to assist, trying to address the historical issues, and trying to work hard to build the credibility. And there were some very talented non-executives that were still on the board of the Post Office. And so I would say the board culture was very positive indeed. And Mr. Parker was a good chairman that was very inclusive in trying to make sure the board was very focused indeed.
You mentioned already Nick Reid. What was your view of him as chief executive in dealing with the issues that arose from the GLO judgments?
He was a strong communicator. He tried to get round the network as much as possible. He would welcome feedback. His style was open and engaging, and he was also detailed. And so therefore, I was very positive about his approach to rebuilding trust between the Post Office and the sub-postmasters.
And what about the relationship between Nick Reid and Alistair Cameron? Do you have any views on that?
In what terms?
Well, I'm just asking if you had any comments to make on if it was an effective working relationship.
I never saw that it wasn't an effective working relationship.
Do you have any other views on that matter?
No, sir.
What are your views on the composition of the board when it left, in terms of did it have sufficient expertise to deal with the matters before it?
As I said earlier, I believe it was the year before I finished my second term and stepped down. And Ben Tidswell, who joined the board from a legal professional background, was a great addition to the board. And I felt that was very positive indeed. the chair of the audit committee was extremely competent and an experienced executive, and as was one or two of the others. A replacement had started for me, but that was his first board meeting, so it's impossible for me to comment. But I was certainly very positive, although it was going through a period of change with me leaving and with the chairman going to leave later in 22.
The inquiry will be considering issues of corporate governance and the role of non-executive directors in when it considers matters. Do you have any thoughts or recommendations, having reflected on matters, for any changes or proposals you would make that to corporate governance or the role of the non-execs to avoid something like this happening again?
I think I'd have to reflect on that and take a bit more time to answer the question in any sort of level of detail. It's very hard when you are attending as a non-executive 1 or 2 days per month to get, other than the agenda and what is on a board or a subcommittee agenda, is very hard to get a much stronger feeling throughout the organisation on the culture or the effectiveness. I certainly feel that the induction could be strengthened, both in Post Office and on the government's expectation of a non-executive in that company. But I viewed Post Office as a trusted institution that had been around for hundreds of years, and I felt no requirement to do strong investigations or due diligence before joining. It's something I regret now, and I should have paid more attention to. But I think the training and induction and the expectation of the major shareholder, and I think also the complication of the business, because at the time, you know, this was a financial services banking joint venture. It was a broking business. It was a payments business. It was a mails business. It's a parcels business. It was a complex business. And I think making sure that any induction and process takes account of all those businesses would be more preferential.
Just picking up on one thing you said there. Do you think that 2 days per month for a non-executive at Post Office is insufficient time to carry out the role effectively?
I think 2 days per month under normal circumstances, and I caveat that because most of the non-executive appointments, leaving aside Post Office itself, most of non-executive appointments are 2 to 3 days per month. That's a common figure and should be sufficient. In the case of what has happened here, patently it would have been, and we ended up spending a lot more and allocating a lot more time to Post Office, but normally it should be sufficient.
Thank you. Those are the questions I asked. Sir, I'm just going to check if there are any co-participant questions, and then if there are, we can, or if there aren't, we can take a view on whether it's an early lunch or a break, I think. It's just Ms Patrick who would seek 5 or 10 minutes. I'll just look at the transcribe. The transcriber is happy to continue, and we could then take an early lunch. So
yes, by all means. Over to you, Ms Patrick.
Thank you, sir. Mr McCall, my name's Angela Patrick, and I asked questions on behalf of a number of sub-postmasters who were prosecuted and convicted and have since had their convictions overturned. And you can see 2 of my clients are sitting next to me, Mrs Hamilton on the left and Ms Hall on my right. And you'll be glad to hear I've got 1 issue and 1 document I want to go to and ask you about. But before we go back to that, I just want to set the scene. You can recall, I think, Mr Stevens took you this morning to a minute from February 2019, where the issue of the Deloitte reports were discussed. And he asked you, so your evidence appears to be that you were told of the Deloitte review, the report, You attended a board meeting at which you asked Mr Parker why he didn't provide the information earlier, and then you replied, yes, that's correct, having seen the minute. He also took you to a minute of 21st of February, and I think, if you can recall, that's the one where you and Mr Parker attended by phone. And again, Deloitte and remote access were discussed. And can you recall that exchange with Mr Stevens this morning?
Yes, I do.
Of course. And that'll just set the scene for the document. Can we look at Paul 2011699, please? I'm sorry, we'll just wait for it to come up. And if we can scroll to the last page, which is page 3, I'd be very grateful. And if we can scroll a little bit further down, please. You see there at the bottom, you can see there's a dial-in detail for that minute, that meeting, GLO subcommittee, 21st of February 2019. You see the meeting was to be 11 to 12, and the various dial-in details, including your name there. Do you see that, Mr McCall?
Yes, I do. Thank you.
Can we scroll up a little, and we can see where this email goes? If we scroll a bit further, I can see that first message. You see there's a message there from Tom Cooper, and it isn't copied to you, but just to set the scene, he says, Jane, one follow-up from the call, presumably that was the meeting earlier that morning, so the timing on this is 12:47. If we read it together, he's asking, to what extent can the court protect Paul against journalists overstating the evidence horizon? If a journalist writes that there's evidence of systematic problems with Horizon, when in fact no evidence exists, will the court help us at all? Seems to me it's incredibly important to have a press strategy which seeks to stop misrepresentation by journalists and seeks to protect Paul's business today against the implication that the current system doesn't work properly. And that's to Jane McLeod, I think. There's no other Jane on the message. Now, this is after the meeting where there's a discussion with Mr Degar Robinson, and there's a conversation about the Deloitte report and remote access. Now, here Mr Cooper's asking about how to protect the position of the Post Office in press reporting during the GLO, isn't he?
Yes, that's what's written there.
Was that a concern that was shared more widely on the board or on the subcommittee?
Not particularly.
But the subcommittee we see here could be involved in strategy for the Post Office during the GLO, including on communications and interaction with the press. Is that right?
No, I think the subcommittee was involved in items that were escalated by the day-to-day executive who was managing the litigation.
It would be open to you as a member of the subcommittee in the way that Mr Cooper is here to ask questions about anything around the strategy on the litigation. Is that fair?
That's fair, but as you can see from this email, I'm not copied on the email, so...
I'll stop you there, Mr McCall. If we can scroll up so we can see the next message in the thread. Stop there. We see Miss Venel's replies very shortly thereafter at 1:21, and she does copy you in. Can you see that there, Mr McCall?
Yes, I can.
Yeah. So you are copied in, and you see Mr Cooper's question to the other members, to the members of staff, but also copied to his fellow subcommittee members. So you did receive that message, didn't you?
It says there's an email, and I'm sure I then received it.
Okay. And I just want to have a quick look at what Miss Venables is telling you about the strategy in response to Mr Cooper's inquiry. She says, yes, we defend robustly, but we avoid adding extra coverage. And if you recall, this is after the meeting where we know that you've had a conversation about remote access and Deloitte. As before, we hold the ground. The system is robust, and not comment any further during the trial. So aggressive, no. Robust, absolutely no question. And if we scroll down a little bit further, we see she's talking a little bit about the strategy and how it's gone so far. The strategy has worked well so far, which is to minimise coverage in mainstream media. Therefore, we don't engage in any public debates. We have strong lines, but we add no oxygen by commenting or engaging. This is not new news, despite how the claimants will present it as that. Our approach is to curtail interest as much as possible. And then she goes down to sort of talk about the question about legal options that Mr. Cooper has raised. Your questions re how far we can go legally are important. We have used injunctions and demanded apologies in the past. They're both to be used, but with caution. They gain more coverage, which is not always balanced, but there are tools in the box. Portland are very experienced about this too. Portland, was that an external PR agency that the board was consulting?
That would be the responsibility of the executive. I don't know the name Portland specifically, and I never met anyone from Portland, so I'm presuming in the circumstances of what I see written, it would be managed by the executive, and that's who they are. So
here, Ms Reynolds is writing to the whole subcommittee, updating you on the approach they're planning to take to the strategy around the GLO. She's saying, maintain the position that the system's robust, strategies to be aggressive, no. Robust, absolutely no question. Was this the strategy towards press engagement on which the subcommittee was essentially agreed?
Well, the subcommittee weren't responsible for the press engagement. There was a communications director working with the the CEO and the General Counsel, and they were responsible for all the day-to-day strategy around communication and what was said by the company, in addition to shareholder input. So the subcommittee wasn't on a day-to-day basis involved in this.
Okay. Can we just scroll up a little to see the last in the line of questions, last in line of communications? On the first page, I think we should see. Stop there. We see Mr Davies responds to Miss Venel's outlining of the strategy, and again copies you in. I will take this very briefly because it's essentially repeating the message but with some greater detail. External communication strategies to minimise negative coverage by holding the robust line we have deployed throughout. And so doing, we've succeeded in minimising coverage in the mainstream media. I don't want to cover this in great detail because he goes over how different approaches have been taken in the press. But he says, there is a group of journalists who have staked their professional reputations on campaigning on behalf of those who have now taken us to court. They, and one in particular, drive most of the periodic increases in external coverage. We sought to engage with this group, but there's an unwillingness to engage with our side of the story. And if we skip down a little further, Private Eye has also featured the issue regularly, claiming Post Office has knowingly covered up evidence of what it calls the deeply dodgy Horizon system. We believe the content in Private Eye is almost certainly provided to it by one of the campaigning journalists who have staked their reputation on proving that the Post Office has conspired to see otherwise innocent people jailed or penalised. Now, first, Mr McCall, can I ask you, how closely did Mr Davies work with the subcommittee at this time during the development of strategy on the GLO?
As I said, let me repeat again, Mr Davis, the General Counsel and the Chief Executive were responsible for the communication strategy and anything that was responded to by Post Office. The subcommittee wasn't day-to-day responsible at all.
Just stop you there. I've got one last question for you, Mr McCall. This is February 2019. This message, which goes to the whole subcommittee, talks about the campaign. There's been a campaign by this stage for a very long time. in which my clients, including Mrs Hamilton and others, were deeply engaged. They'd managed to get their case into court. There was a subcommittee of the board set up to lead the strategy on that litigation. You are the senior, independent, non-executive director. You've agreed today that part of your role was to represent the interests of the shareholder, who is the taxpayer, the government. Are you really suggesting, at this point, and if I can remind you, you've accepted, the board would have been aware that the picture on remote access was very different from that which may have been presented at an earlier stage? Are you really suggesting that if you thought that the strategy that was being presented by the executive team was out of step or might be causing some risk to the business, that you could not step in and say something?
I'm suggesting to you, and I'm answering to you quite firmly, the subcommittee is not responsible for the communication strategy. There was a document produced earlier today talking about the strategy of the litigation. I didn't sit on the subcommittee of that. I had never seen that document before. And I'm copied in here on an email, but I'm not responsible for the communication strategy. I was the senior independent director, and I accept that. And I received the email, I'm absolutely certain, but I wasn't responsible for the strategy.
Okay. Thank you very much, Mr McCall. I don't have any other questions for you.
Is that it, Mr. Stevens?
That's it, yes, sir. So, yes,
Right.
That's all the questions.
Fine. Well, thank you, Mr. McCall, for making a witness statement as the inquiry requested of you. And thank you, too, for giving evidence this morning before me. I'm very grateful to you.
Thank you, sir.
Thanks.
So what time should we resume, Mr. Stevens?
So I wonder if we could resume at 25 to 2, and then, because it will be a longer session, take 2 breaks. But that should give us sufficient time, I think, to cover the evidence.
All right. 25 to 2.
Thank you, sir.
Good afternoon, sir. Can you see and hear us?
I can indeed, thank you.
May we please call Kelly Tolhurst?
Yeah.
After me. I swear by Almighty God
I swear by Almighty God
that the evidence I shall give
that the evidence I shall give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Thank you.
Could you confirm your full name, please, Ms Tolhurst?
Yes, Kelly Jane Tolhurst.
As you know, my name is Emma Price, and I will be asking you questions on behalf of the inquiry. Thank you for coming to the inquiry to assist it in its work and for providing the statement which you have. You should have a hard copy of that statement on the desk in front of you. Do you have that?
I do.
It is dated the 19th of June 2024. If you could turn to page 73 of that, please.
Oh, yeah.
Do you have a copy with a visible signature?
I do, yes.
Is that your signature?
It is.
For the purposes of the transcript, the reference for Ms Tolhurst's statement is WITN 109-30100. Ms Tolhurst, your witness statement is now in evidence and will be published on the inquiry's website in due course. As such, I will not be asking you about every part of your statement, just certain specific issues which are addressed in it.
Okay.
I'd like to start, please, with an overview of your professional background and career in government to date. You explain in your statement that you, before taking up an elected role, ran a marine business for 17 years.
That's correct.
Training as a marine surveyor during this time.
Correct.
You were elected to Medway Council in 2011, representing the Rochester West Ward.
Correct.
You were elected as an MP in May 2015.
Yep, correct.
You served as Assistant Whip to the Treasury from the 9th of January 2018 to the 19th of July 2018.
Correct.
And following that, you served as Parliamentary Under-Secretary of State for the Department of Business, Energy and Industrial Strategy from the 19th of July 2018 to the 13th of February 2020, where you were responsible for small businesses, consumers and corporate responsibility.
Correct.
This was your first ministerial appointment?
Yes.
And was it in this role that you became involved in some of the matters which the inquiry is concerned with?
That's correct.
You went on to serve for a little over 6 months as Parliamentary Under-Secretary in the Department of Transport,
That's
followed by serving as Parliamentary Under-Secretary at the Ministry of Housing, Communities and Local Government between September 2020 and January 2021.
correct.
You were Deputy Chief Whip in the Commons from July 2020 to September 2022. You then served as Minister of State at the Department for Education for a short time, before serving from the backbenches until the recent election.
Correct.
Is it right that the only time you have had involvement in matters relevant to this inquiry was when you were Parliamentary Under-Secretary of State for the Department of Business, Energy and Industrial Strategy?
Yes, that's right.
Moving then, please, to the civil servants who assisted you when you were Parliamentary Under-Secretary at Bays. If I have understood your evidence in your statement correctly, there were, broadly speaking, 3 pools of civil servants who provided you with assistance on post office matters. First, private secretaries from the department's private office.
Yes.
Second, officials who were subject matter experts in particular policy areas, who, for the part of your role which related to the post office, worked for UK government investments.
Yes, correct.
And the third category from August 2018, when it was established, were officials from the post office policy team within Bays. Is that right?
That's right.
So far as your private secretaries were concerned, is it right that they dealt mainly with managing your diary, preparing paperwork for your ministerial box, and managing correspondence?
Correct.
In terms of the advice you received from officials, you address this at paragraph 12 of your statement. Could we have that on screen, please? It's page 4. And towards the bottom of page 4, please. And you say here at paragraph 12, the breadth of a minister's portfolio is such that they have to a greater or lesser extent, rely on the advice of officials and make decisions on the basis of it. Ministers expect the advice given to be competent, accurate and reliable, honestly given, and on the basis that objectivity has been applied in the analysis of the facts. Why was the application of objectivity in the analysis of the facts important?
In my view, when you're coming in as a minister as potentially an amateur in the space in which you're operating, for example, in this particular instance, I didn't have any particular experience within the post office or that kind of structure. So, for example, the objectivity would be important because obviously you would want to be given advice where you feel that they've weighed up both sides of things. So you would be confident in the fact that you were taking a decision or had information that was sound and also had been looked at from a number of different points of view. So I think when they're giving you that advice, it's important that you have that range of the objectivity so that you can make decent judgments based on what's put in front of you.
Turning then to the information you were given about the post office in the early period when you took up your role as Parliamentary Under-Secretary at Bays, you explain at paragraph 9 of your statement that you had a broad policy portfolio covering a range of sectors. And it was such a busy portfolio that it was in fact split in two after you left Bays, is that right?
That's correct, yeah.
So there was a lot to get on top of.
Yeah.
You were given an entire portfolio briefing to start when you arrived in post. Is that right?
Yes, sorry, yeah.
And you also received a briefing on postal affairs specifically.
Yes. For the whole of the brief, it's quite common for new ministers to be given sort of a day one briefing on all the different elements that are included within the brief, because within the brief of a minister there may be things that you would have more sight of than others.
If we could have paragraph 13 of Ms Tolhurst's statement on screen, please. That's page 5. And in referring to that briefing on postal affairs specifically, you say in the last line, I was provided with some outline information regarding the Horizon IT system issues. At paragraph 14, is that your assessment of what you understood those issues to be at the time? Paragraph 14 there.
Yes, it was my assessment of what, the information that I had at the time, yes.
And you say, I understand at that time that a civil claim was being brought by a number of SPMs in relation to accounting losses suffered in branch as a result of the Horizon IT system, I understood that SPMs were alleging that there were widespread problems with the system and that Post Office Limited denied this. I knew that several SPMs had been convicted for accounting losses. You refer at paragraph 15 of your statement to briefing documents which you received on the 16th of August 2018.
Yeah.
Looking first, please, at how these briefing documents came to you, could we have on screen, please, UKGI 408342? And starting, please, with the original email dated the 10th of August 2018, which starts about 2/3 of the way down the page. This is from Stephen Clark, from the Post Office shareholder team at UK Government Investments. And going over the page, please. Mr. Clark says, please find attached. Actually, apologies, if we can just go back, please, to who this was sent to. This was from initially from Mr. Clark to the Permanent Secretary's private office, is that right?
Yes.
Going back over the page, please find attached an update submission with 5 annexes on the Post Office Horizon litigation case. This is an info sub to 1, bring Alex up to speed on the case. Was that Alex Chisholm, who was the Permanent Secretary?
Correct.
2, brief Alex on safeguards for handling Post Office Limited's legally privileged information under the disclosure protocol. And 3, focus on plans for the oral briefing on the 10th of September by Post Office Limited's legal counsel. Please note that Post Office Limited have password protected their background briefing, Annex 3, as an extra safeguard. The password will follow. For the benefit of copy addressees who saw this sub in draft a few weeks back, I should explain that the sub was put on hold while we collected the required signatures for recipients on the closed distribution list. And then there's a request not to share the submission beyond the closed distribution list. This email was then forwarded to your private office, going back to the first page, please, on the 16th of August 2018. So if we scroll to the top, we can see from Stephen Clark to, we can't see the full email address, but that is to your private office, isn't it?
Yes.
And just scrolling down a bit, please. It says, hi, Sam. Was Sam your private secretary?
Yes, she was. One of them.
One of them.
Yeah, one of them.
As discussed, here is the info submission that went to the PermSec on the Post Office Horizon litigation. I'm sending this now for information, as we won't be getting any comments back from Alex before the Minister goes away again. The recipients list in Annex 2 has been updated, and there's a reference to getting the NewsFad on board. We can see from the list of attachments with the update submission, just looking there under subject, the first attachment is the submission itself, and then we have 5 annexes listed. So it appears from this, doesn't it, that both the submission itself and all 5 annexes were sent to your private office on the 16th of August.
Yes, sorry.
The transcriber has to get your words.
Yes, so, apologies.
Thank you. It appears from your statement that you read the submission dated the 10th of August 2018, which was the first attachment to this email, because you refer at paragraph 23 to background information which you derived from the documents provided to you on the 16th of August, making specific reference to a paragraph of that submission. Is that right, that you read the submission itself at the time?
I believe I did read the submission at the time. Being a new minister, I had quite a lot to get through, and I would have read it because I did try and read everything that was put in front of me, which sometimes was a frustration to some.
Was this the first briefing that you had received specific to the group litigation since becoming Parliamentary Under-Secretary?
I believe so.
I'd like to explore, please, whether you read any of the annexes which were sent to you, which were discussed in the submission. If I can just stop you there. In your statement, it's not entirely clear which of the annexes you think you would have read at the time. So if we can just take that in stages. But forgive me, you wanted to say something.
No, apologies. I was sort of preempting what you were going to say. In relation to the annexes, I remember obviously reading the briefing. The protocol was something that I obviously remember obviously being put in front of me, because obviously it was subject to me being given further information. Yeah, I don't remember what I was feeling at the time in August when I would have read those, and I may have read them sort of later than it might not have been on the 10th of August. It might have been sort of later on when the documents may have been shared with me.
Well, they were sent to your private office on the 16th of August.
Oh, sorry, 16th,
so I think
sorry,
it would have been after that date
if
you did. But let's just take it in stages. If we can have on screen, please, paragraph 20 of Ms. Tolhurst's statement. That's page 7. So you say here, as to the other annexes, Annex 1 was the information sharing protocol, which you referred to just now, and Annex 2 was the onboarding protocol. I do recall receiving those documents at the time, but I do not remember reflecting on them. Did you read those 2 annexes?
I believe I did.
You would have been aware from those documents, and in fact from the submission, that Post Office Limited, BAYS and UKGI had by this time established a disclosure protocol which governed the flow of legally privileged and confidential information in respect of the Horizon litigation from Post Office Limited to UKGI and BAYS. Do you recall that?
Yes, I do recall that.
Could we have on screen, please, paragraph 17 of Ms. Tolhurst's statement? That's page 6. And you say this of Annex 3. At paragraph 8 of that submission, it is recorded that following the agreement of the protocol, Post Office Limited's legal counsel provided an initial background briefing on the litigation, Annex 3, including their KC's view on the merits of the case. And you say here, I did not receive this Annex 3 at the time and have not seen it since. Just to clarify, Annex 3 was sent to your office under cover of the email of the 16th of August. We've seen that from the email, albeit that it appears in the original email sent, it was password protected. Can you help with why you say here that you did not receive it?
Well, I don't remember receiving it, and I hadn't seen it, well, as I said in the statement, but I don't remember being given the QC's views on the merits of the case. So that's all I can sort of, genuinely sort of, with what I can remember from the time and sort of looking back now.
Looking, please, to the 10th of August submission itself, could we have that on screen, please? The reference is UKGI 18266. And going, we can see there at the top the date and the submission title, Post Office Limited, Horizon Litigation Update. Towards the bottom of page 2, please, there is a heading, Litigation Background Briefing and Updates. And paragraph 8 underneath that contains this. Following the agreement of the protocol, Post Office Limited's legal counsel provided an initial background briefing on the litigation, Annex 3, including their case QC's view on the merits of the case, and has since provided a further update, Annex 4, following discussion of the case at Post Office Limited's last board meeting on the 31st of July. For ease of reference, in Annex 4, UKGI has highlighted in yellow any information that is new and worthy of note. So this was in the submission itself, flagging the existence of both Annex 3, which contained the QC's view on the merits, and a further update from Post Office Limited's legal counsel at Annex 4, with anything that was new and worthy of note highlighted. Did you ask to see either of those documents when you read this submission?
So I generally don't remember. All I would say is that at the time it would have been over the recess period. I don't remember specifically asking for that, so I would be wrong to say anything else other than that, really. But it would have been a period where we weren't sitting, I wasn't necessarily in the department, so I may have been in the constituency. So it might have been something that I maybe didn't request.
Looking, please, to paragraph 11 of the submission, a little further down the page. This explains the purpose of the oral briefing from Post Office Limited's legal counsel, which was scheduled and which you were going to be attending for the 10th of September. Is it right that you think this in fact occurred on the 17th of October?
Yes, I believe it did. I've sort of checked my diary, and I actually had, I think I had another, what they call a statutory instrument debate at the time that it was originally proposed. So I think that may have been the reason why it didn't take place.
And this is the explanation given of the meeting. The briefing is confirmed in your diary and the Minister's diary for the 10th of September. A proposed agenda and list of attendees drawn up between UKGI and Post Office Limited is attached at Annex 5. Post Office Limited's legal counsel Jane McLeod, Chair Tim Parker, and CEO Paula Venables via telephone and video link will brief you on the key issues at stake, as well as on the financial, reputational and operational implications, which could be considerable, of an adverse ruling at November's Common Issues trial and or at the Horizon trial in March 2019, and Post Office Limited's contingency plans for dealing with these risks. This will be an excellent opportunity for you and the Minister to exercise shareholder scrutiny and seek reassurance on any issues of concern. So this was flagging up, was it not, that there were financial, reputational and operational implications, potentially considerable ones, if there were adverse findings for Post Office Limited at either Common Issues or the Horizon Issues trials,
Yes.
and that contingency plans for dealing with these risks were in train.
Yes.
It was also flagging what was expected of the Permanent Secretary and you at the meeting, which was an exercise of shareholder scrutiny, as well as it being an opportunity to seek reassurance on issues of concern. When you read this, did it make you think to ask for Annex 3 or Annex 4, the QC's views and the new and noteworthy information?
Genuinely, I can't say if it did or not at that particular time. So I can't honestly tell you whether or not what I thought about in relation to those annexes you've outlined.
Could we have on screen, please, paragraph 24 of Ms. Tolhurst's statement? That's page 8. Your comments in this paragraph are made in the context of the documents sent to your office on the 16th of August, including the submission itself. And in the first half of the paragraph, you say this: I do not recall any advice being given at the time regarding the risks of the litigation. I was not given the impression that Post Office Limited were anxious about the litigation or that there was any particular risk involved with the litigation over and above the inherent risk associated with any legal dispute. Can you help, please, with why you took from the submission, and paragraph 11 in particular, that there was no particular risk involved in the litigation over and above the inherent risk of any legal dispute?
Well, in relation to, I'm just looking at, I mean, ultimately, I think at that particular time, all the informal, the briefing that I'd been given sort of didn't suggest at that particular time that there was any thing particularly that I should be aware of, or that would mean that there would be sort of more well, as big as it obviously what we now know, the risks and the troubles relating to the litigation. So I hadn't been given the impression, new into the post, that there was anything particularly to worry about. Obviously that was my understanding sort of going into that meeting. At the time, I suppose I was more concerned with actually any kind of litigation, what that would mean for the Post Office, what it would mean for the government. But that was sort of the limits of my sort of thinking at that time.
You say in the paragraph above, paragraph 23, that the only background information you derived from the documents was that the independent investigations by Second Sight found no evidence of flaws in the Horizon IT system, and that is taken from paragraph 12 of the submission itself. Given that this was background information which you derived from the documents at the time, did you ask to see Second Sight's report?
No, I didn't ask to see Second Sight's report.
At paragraph 25 of your statement, you say that it was obvious, notwithstanding your comments at paragraph 24 about what you appreciated in terms of risk, that the litigation was going to be an important part of the Postal Affairs brief. And you say that you did not think that the information provided in August 2018 had given you the information necessary to provide effective leadership from within BEIS in respect of the litigation. You go on at paragraph 26 to say that you are someone who is interested in the detail and concerned to have all of the relevant information before taking a decision. And over again, please, at 27, you say this: "For that reason, I requested further information, and I was provided with the short further document entitled Briefing for Kelly Tolhurst MP, Postmaster Litigation. The document itself is undated. I do not recall exactly when I received it, but I'm sure it was provided after the 16th of August 2018 and before the meeting with Post Office Limited took place on the 17th of October 2018. It is a top-level summary document drafted by UKGI. I return to it below. That document was a one-page high-level briefing, as you say, but you were provided with two further briefings between August 2018 and the meeting which was discussed in the August submission, that of the 17th of October 2018. The first of these was a briefing ahead of a meeting you had with Paula Venables on the 3rd of September 2018. And you addressed that briefing at paragraph 28 of your statement. And you quote the section which raises concerns, there were concerns which were raised by UKGI that Post Office Limited had not done enough to prepare for potential business, reputational and financial implications of losing the litigation. Do you recall discussing this with Paula Venables at your meeting with her?
I remember, obviously I remember meeting with Paula Venables. I remember touching on it, but I would say that it was a touching on the litigation. It was very much an intro meeting, and obviously one of the things that there were other sort of postal or post office issues that were relevant as well, and my interest was obviously as a minister, how could I affect and be helpful to the post office in relation to some of those other duties and responsibilities. So I do remember speaking with her. I remember the meeting, but I remembered it only being sort of touched on as opposed to gone into any great depth at that particular time.
And indeed, in your statement, you indicate that only 5 minutes of the meeting was allocated to the litigation as opposed to those other issues. Is that right?
Yes, approximately.
But this was, again, flagging up that there were business, reputational and financial implications of losing the litigation, this briefing ahead of your Paula Venables meeting, wasn't it?
Yes.
At paragraph 29 of your statement, starting 5 lines down, you say this: "I note Mr. Aldred recorded that Miss Venables had passed on the advice of Post Office Limited's leading counsel, that in summary, Post Office Limited will likely lose on some contract clauses, but not on the highest impact ones. Whilst I do not now recall the detail of the point made, that fits with my understanding at the time. I remember having the general impression that the Post Office Limited had confidence in its overall defence to the claim." There are 2 parts of the note of the meeting with Paula Venables on which you comment in your statement at paragraphs 30 and 31. And at paragraph 30, you say this: "I do agree with Mr. Aldred's note that I emphasised the need to provide plenty of detail, and Paula Venables said Post Office Limited would be in a much better position to do so after further briefings from their QCs and hopefully more information on the claims. This fits with my memory of dealings with Post Office Limited during my time at BEIS. Post Office Limited always seemed willing to answer questions when asked, but I did find that they were sometimes difficult about what information they would volunteer. There was never a refusal to provide information if it was requested, but I did feel that details were not always forthcoming in a proactive way. Even at this early stage, your first meeting with Paula Venables, was this the impression you formed, or did that impression come later?
I think the impression would have come later. As I said in my statement, I was new to the brief. I wanted to understand as much as I possibly could. It would be usual for me to ask for further information or as much detail as I could. So it would have been normal for me to have said to Paula, provide me with as much information as possible. But as I sort of said in the statement, there was never I never ever detected any sort of resistance to giving me that information directly from Post Office. But obviously I felt, and when I reflect back, looking at obviously the documents and reflect back on that time, I did feel that I was asking for information all the time, or wanting further information. So obviously that's what's sort of formulated my view on this.
Was this an impression you formed when you were Parliamentary Under-Secretary at Bays, or is this one you have formed on reflection?
No, it was what was happening when I was actually within the department. But obviously at this particular time, so that meeting with Paula was on the 3rd of September. I had only just recently been appointed, and at that particular time, there were a number of just to sort of set the context, there were a number of big areas within my portfolio at Bays that required me to sort of get up to speed on pretty quickly. So it was, and actually this was the sort of first intro meeting. So that's why I was pleased actually when she suggested that, sharing information wasn't going to be a problem, but obviously as time went on, it was me asking for that information.
At paragraph 31, you say this: I also note what Nick Parker writes in the first paragraph. Paula frequently confirmed that challenge from Her Majesty's government is good, but also asked that HMG ensures the positive developments in Post Office are made clear, and that HMG continues to stress the important role that Post Office plays in communities up and down the country. Reading this comment now, I do feel that Post Office Limited was more interested in the department challenging Post Office Limited for the appearance of challenge, rather than sincerely listening and changing course in response. I got the impression that Post Office Limited expected the department to be positive about Post Office Limited, regardless of the scrutiny that the Minister or department wished to apply. Again, is this an impression you formed at this point in September 2018, or one which came later?
It came later, yeah.
As far as you are aware, was this approach and attitude from Post Office Limited ever challenged by Bays or raised with the Post Office Limited board members at the time?
Sorry, at the time of the 3rd of September.
At the time that you had that impression and you had that concern,
yeah.
Was that approach and attitude that you described there ever challenged by the department with Post Office board members?
So I don't know if it was challenged by anyone within the department. I know that I had expressed frustrations over that period, particularly on this point of not feeling that maybe I was getting the information that I needed or that should be coming my way. I can't say that it would be wrong for me to say that I directly challenged Post Office Limited on that particular point. But I think that my feelings and frustration of that was understood by the team at Bays and the UKGI members that I spoke to and interacted with.
In general, did you feel restricted in your ability to change this attitude or approach, or to ensure that Post Office Limited acted upon suggestions made by Bays?
I would say that, I'm generally somebody who would, if I have an opinion and I'm not happy with something, I would generally make that clear. I would, I would have thought that. I mean, I'm just sort of making, I'm just trying to think what I may have done, sort of looking at it now, rather than sort of giving you any solid, solid sort of factual or answer to what actually would have happened at the time. But I think that, it was understood that I was, I felt frustrated at that particular, after that period of time, by sort of the reactions and information that was coming through, or that sort of of appearance. So, yeah.
The second written briefing you received further to the August submission and ahead of the 17th of October 2018 meeting was the detailed paper you address at paragraph 35 of your statement. Going over the page to that, please. And again, please. And here you say, on the 11th of October 2018, I received a briefing authored by Post Office Limited for the 17th of October meeting. The briefing was extensive, although section 2 setting out the background to the litigation was relatively short. I did not understand this to be a meeting about litigation strategy or the merits of the claim. It was really just a meeting about what was happening in the litigation. Just picking up there on your understanding of the purpose of the 17th of October 2018 meeting, this was, you think, the adjourned meeting, which was addressed in the 10th of August submission. And in that submission, the meeting was described in paragraph 11, which we looked at, as an excellent opportunity for you and the Minister to exercise shareholder scrutiny and seek reassurance on any issues of concern. And it was also envisaged that there would be some scrutiny of Post Office Limited's contingency planning at the meeting, wasn't it? Because that was why you were briefed ahead of the Paula Vennells meeting to request sight of the contingency plan in advance of the meeting. Do you recall that from the documents?
Yes, I do recall it from the documents.
Can you help, therefore, with why you viewed the meeting as really just a meeting about what was happening in the litigation?
Yes. So, again, this would have been the first sort of major meeting that I would have had around the litigation in relation to the Post Office. And it was an opportunity, and whilst the contingency plan was an element, this was an opportunity for them to brief me about what was happening with the litigation, and an opportunity for me to discuss and ask questions. So for me, I felt that it was very much about the whole litigation, not just about the contingency planning. And obviously, I had limited knowledge. I'd only had what I'd read prior to that, or informal conversations. So it was an opportunity for me to meet with all of the people involved and ask questions and listen to what they had to say.
But you're not saying by it was just about what was happening in the litigation that you didn't have the opportunity to apply that shareholder scrutiny at that meeting, because that was the stated intention, wasn't it, in the submission from August? Yeah,
I mean, at that particular meeting, I was concerned about to have more information about the litigation. I remember being able to ask questions. I asked questions about I did ask questions of the merit. I asked questions about the liability, what it would mean, what the Post Office felt about the outcome or potential outcomes of the litigation. So I think from my perspective, I wanted to use the meeting as a better understanding of what the current state of play was. I was very much aware that this had been going on for a long period of time, and I wanted to be able to perform correctly as a minister as in the best way I could, and the only way I would, I believe, is to understand what's going on in the detail. So whilst contingency planning was a part of it, I think from my perspective, it was very important that it was an opportunity for me to ask questions.
Could we have on screen, please, POL 30s22976? This is the briefing paper for the 17th of October 2018 meeting. Starting, please, with page 2, we can see a table of contents, and there were sections listed as 1 to 7, the executive summary, background to the litigation, key issues at trial in November, operational improvements already underway, contingency planning, communication strategy, and settlement options. You've said in your statement that you were interested in the detail as a general rule. Did you read all of the sections of this briefing when it was provided to you?
Yes, I would have done ahead of that meeting.
Going to the executive summary over the page, please, at paragraph 1.2. Under the heading, "What is the case about?" It says the case represents the culmination of a series of campaigns by disaffected postmasters and others, including a number of MPs on both sides, who believe that Post Office wrongly attributed branch losses to those postmasters, and that as a result they suffered financial and reputational harm. A theme of these campaigns is that flaws in Horizon, the in-branch point-of-sale system, were the cause of these losses. Going over the page again, please, at 1.8, the number of claimants is identified there as the group of 561 claimants. And then going to page 6, please. This is the second section, the background to the litigation. And at 2.2, there is this. In 2012, a small number of mostly former postmasters, under the banner of Justice for Sub-Postmasters Alliance, and with support from some MPs led by then MP, now Lord James Arbuthnot, claimed Post Office's Horizon IT system had caused losses, shortfalls in physical cash against cash holdings recorded on Horizon, which they had had to make good. In some cases, they had been prosecuted for these losses, usually for false accounting, theft, or both, while in other cases they claimed that it led to their contracts with Post Office being terminated, causing them financial loss and other personal harm, including bankruptcy, divorce, and emotional distress, including suicide. So this briefing was informing you that sub-postmasters had alleged that the IT system had caused losses which they'd had to make good, yes?
Yes.
This had led to some people being prosecuted for false accounting, theft, or both.
Yes.
Others having their contracts terminated with the consequences we see there.
Yes.
And they had had support from some MPs led by Lord Arbuthnot.
Yes. Yes.
Did the nature of the allegations being described here cause you any alarm by their very nature?
Yes, of course. Anyone sort of being accused of breaking the law or doing something regarded as illegal and the consequences of that, of course. You know, and for me, absolutely, that's why, you know, I was keen to understand more about what had gone on and what the current situation was with the Post Office.
Did this paragraph cause you to ask yourself whether you needed to test what you were being told by the Post Office about its position on the allegations?
At this particular time, at this particular meeting, no. And the answer to that is, again, this was the first big meeting that I had had with the Post Office to talk about the litigation in any kind of detail. And I was just formulating my views. I didn't have any developed views really prior to taking on the role as a minister. So, you know, of course, it's reading it's really concerning, but it didn't sort of, that particular paragraph in that briefing didn't, you know, I didn't, as you say, didn't make any further decisions based on that.
Did you understand when you read this briefing that it was the Post Office which had been doing the prosecuting?
Yes.
Did that aspect of it cause you any concern taken with the information here in paragraph 2.2?
Yes. Of course, any kind of private prosecution is of a concern, when and especially when it's being done by an organisation. This, I think, I think I mentioned further in my statement, but this is where I sort of asked the question about, you know, what the Post Office really, you know, what the situation was with regards to the litigation, because I did feel that this was a situation where you had a very large organisation taking private prosecutions against, you know, excuse the phrase, small businesses or individuals in some cases. And so for a large organisation to take that kind of action against, you know, relatively small players, excuse the expression, you know, they must have been pretty sure or confident in their position to move that forward. So obviously, you know, that's how I was feeling at the time, and obviously I was getting to know what was going on and developing my views and thoughts and trying to suck up as much information that was being given to me.
At paragraph 2.3, there was this: in response to these assertions, Post Office appointed independent forensic accountants Second Sight to perform a top-down examination of Horizon. Second Sight issued a report in July 2013, which concluded that there was no evidence of a system-wide (systemic) problems with the Horizon software, but identified some areas where Post Office could have done more to support individual postmasters. This was the second reference to Second Sight that you'd had. When you read this, did you ask to see Second Sight's report?
No, I didn't ask to see Second Sight's report.
And why not?
It wasn't at the time. I can't really give you an answer as to why I didn't ask to see their report. I was making a judgment on the advice that was in front of me. I would have expected that the briefing to have given me sort of factual and relatively, you know, truthful information, but I didn't ask to see that, and I would have taken what I was given here on face value.
Could we have on screen, please, paragraph 36 of Ms. Tolhurst's statement? That's page 12. You refer here to paragraph 2.3 of the briefing document, so that's the paragraph we've just looked at, referencing second sight. And you say in the last sentence of the last two sentences, I remember being reassured by this. I understood no evidence of system-wide systemic problems to mean that there were no fundamental flaws in the system that could affect SPMs more widely, although there may have been one-off issues arising from user error or occasional bugs. Going back a page to paragraph 33, please. You say, my general impression at this point in time was that Post Office Limited did not consider there was a serious problem with the Horizon system, albeit there may have been occasional bugs or errors in the system affecting individual SPMs. I understood Post Office Limited thought there was a possibility that the court may find against them on various contractual points or in respect of those occasional bugs or errors, but did not think they would lose on anything significant. So the reference here to occasional bugs or errors in the system affecting individual SPMs, did you at the time question whether this system, which you understood to have bugs or errors affecting individual SPMs, even occasional ones, could be described as robust, the language which was being used by Post Office?
So at that particular meeting, the sort of terms, occasional bugs or errors, I'm not I'm not a technical expert, particularly with computers and computer systems. So I wouldn't have, I wouldn't have maybe have asked that question. But I think for me, it was very much about, I was sort of at that particular meeting give assurances that, the representatives themselves, the people in the room were telling me that there was no systematic issue. It was played down in the sense that it was only very minor. So I, again, I took what I was told on face value at that early meeting, without sort of probing further what bugs or errors could potentially be. However, I'm not an expert in tech or computers, so even if I had I'm not sure what information they would have given me to maybe lead me to take different views or ask for something further, if that sort of makes sense.
Taking it fairly simply, did you understand these occasional bugs or errors to be material? That is, they were affecting SPMs in the way they claimed, causing accounting difficulties? Yes, I would say so. Did you question whether these occasional bugs or errors were visible to sub-postmasters when they occurred, or whether illusory losses caused by bugs could be told apart from genuine losses by the Post Office?
So in relation to the bugs or errors in the system, I didn't ask and I didn't have information about those specific bugs or errors and potentially how they were affecting postmasters. I definitely was looking at it from more of a global level, more of a top level issue, rather than the individual specific points, which is that's an honest sort of position of what I was thinking at the time.
Do you recognise now that absent bugs or errors being visible to SPMs or distinguishable from genuine losses, wrongful action might be taken against someone, whether a sub-postmaster, their staff, or a Post Office employee, on the basis of unreliable data without anyone knowing?
Yeah, and it's terrible.
Did you recognise that at the time?
No, I suppose, I can, my as I say, at that particular time, I wasn't thinking about the particular bugs and the errors and the specific impacts that that might have had. But absolutely, I mean, having been led to believe that, or being told by Post Office that there were no systematical errors with Horizon, I suppose in some respects gave me some confidence and some comfort that the only errors were incredibly minor and maybe didn't have the impact that I now know had on the postmasters. That's the best I can, yeah, but that's my view on that, yeah.
Do you think you should have recognised the risk of this at the time? Do I think I should have recognised? Absolutely. I mean, I'm sure there's things that, in hindsight, that I may have been able to recognise at the time. At the time, I was, I honestly didn't recognise that issue or those issues were, problematic in that sense. I mean, there's lots of things I would wish I had done or said or done differently. I can't make any sort of excuses for that. So is that a convenient moment for our first short afternoon break?
Yeah.
So 10 minutes, please, sir, which I think brings us back at just after 1:45.
Well, I make it 38. So shall we give
10
ourselves 10 to? Yeah.
Yes, sir.
Fine.
Thank you. Hello, sir.
Yeah.
Could we have back on screen, please, the briefing document for the 17th of October meeting? The reference is POL 30s22976. There is just one last section of this briefing I'd like to go to, please, and that is the contingency planning appendices towards the end of the document, starting at page 32. If we can zoom in a little more, please, so that we can see the table on page 32. That's the page above. We can see here what is colour coding, albeit that this is black and white, colour coding of 5 different numbers in the left-hand column for likelihood of Post Office losing a common issue or an implied term being found against the Post Office. And just scrolling down a little, please, so that we can see. And in the right-hand column, there is a 1 to 5 assessment mechanism for impact. So impact on the Post Office if a common issue is decided in favour of the claimants, and that is defined as a significant adverse impact on the business that could threaten existence as a 5, so the top level in the right-hand column. And on the left-hand column on likelihood of 5 is Post Office is very likely to lose the case, the proposed term is very likely to be implied. And scrolling up, please, just to the top introduction section there. This is the bit of the document relating to high likelihood areas, so that's the likelihood column on the left. And beneath that is a table detailing the 4 common issues assessed as having a high likelihood of Post Office losing the issue or having the implied term found against them. Going to page 37. This is the start of the table relating to high impact areas, so those things in the right-hand column. And the introductory section explains that the table details the 3 common issues assessed as having a significant adverse impact on the business if the issue or implied term were to go against the Post Office. So it's saying there were 3 of the issues that would have that impact. Did you read these appendices at the time? They're not part of the main sections, in fairness to you.
I expect I would have read them at the time. I don't recall, to be absolutely straightforward, I don't recall, but I expect I would have.
Seeing the 4 issues which were assessed as being 5s or likely to lose on points, and the 3 in having a high impact were they to be lost, albeit that the likelihood on those was lower. Did that cause you any concern in terms of the risks of the litigation?
I think that I was concerned about all of the risks in relation to litigation. Going back to the point that I made around the fact, I was concerned of the large corporation against the small individual. I was concerned that, I was concerned that actually looking at the information that I'd had, I was being given all these assurances. So I think that, for me, that's definitely in that 17th of October meeting. I felt that the people that were briefing me were relatively confident of their position, but that worries me just because of my sort of concern over the length of time this has been going on and some of the issues, obviously in greater detail. So I think, in general, I was concerned without being able to draw out sort of specific, particular parts or on different particular clauses. I think I had a genuine overall concern, which I think would have been right for any kind of minister to have an overall concern about any litigation that any sort of government subsidiary would be. So I think I had concern, but obviously none on those particular points, if that sort of makes sense.
That document can come down now. At paragraph 34 of your statement, you refer to this concern, the general concern you had, and you say that you remember at this early stage being concerned that Post Office Limited were perhaps overconfident. Can you explain what in particular led you to form the view that they were overconfident?
Well, I think at that particular meeting, I don't remember at any time there was any sort of suggestion or acceptance that there was a potential for losing any kind of litigation. And I suppose in some respects that's what also concerned me, because the objective approach would be obviously to look at the worst case scenario if you were looking at it. But at all these stages, I suppose, these individuals in the room who had obviously spent a lot of time on it and had been working on this for a long period of time gave me reassurance. And I didn't have any evidence or any particular information in order to challenge what was being put in front of me at that particular time. So that's the sort of best way I can articulate it.
Could we go please to paragraph 38 of Ms Tolhurst's statement? That's page 13. And at paragraph 38 you say this: my overwhelming concern at that time, this is at the point of the October 2018 meeting, was that a judgment against Post Office Limited or settlement of the claim would not cause Post Office Limited a financial crisis. I was very focused on keeping Post Office going as a valued service. This is why it was so important to me that I was provided with information on Post Office Limited's financial position so that proper planning could take place. And at 39, you go on to say this: frustratingly, Post Office Limited were not willing or perhaps not able to provide any concrete advice on their liability at the meeting. I was informed by way of a post-meeting note that for any settlement up to around 50 million, the cost could be borne by the company. Above that, they would need to consider whether it could be funded by Post Office Limited or request additional support from HMG. I wanted more information about the arrangements that would be put in place for Post Office Limited's financial liability, and this is something I followed up on the following month. My understanding was that Post Office Limited were not giving me an estimate of its potential liability, because then it would become a known liability disclosable to Post Office Limited's auditors, which may expose it to a risk of trading when potentially insolvent. Whilst I understood that, I would expect Post Office Limited to be able to give me some clear information, even if it was not an official figure.
Yeah.
You also refer at paragraph 126 of your statement to being told in a June 2019 submission that Post Office Limited's auditors had previously had concerns that no figures were included in the accounts on Post Office Limited's potential liability. From whom did you gain the understanding that the reason Post Office Limited was unwilling to be open about the likely quantum in the claims related to the need to declare the risk to the auditor, which could in turn endanger Post Office Limited's position as a going concern?
Well, I believe actually this was discussed in the meeting of the 17th of October, because I do believe asking the question directly, my question to the Post Office was, what do you think the liability potentially could be to the Post Office? I wanted to understand what that looked like, and they couldn't give me a figure, and that was a major frustration to me, because, and I have to say, one of the things that frustrated me about it was that, I was questioning senior executives of the Post Office about what the potential liability was, and, okay, I hadn't been a senior director of a large organisation like the Post Office, but I couldn't understand why nobody could articulate that to me as the minister. And I thought at this point in the process, they would have had a better understanding of what that figure was. But actually, they couldn't even give me an informal figure. So until after that meeting, I had no idea what the potential liability could be.
We do actually have a draft note of that meeting. If we can have that up on screen, it's UKGI 408554. And it's page 2 of that document, towards the bottom. There's a comment halfway down the page, which is the first one from you, so Kelly Tolhurst, brackets KT. And then a little further down, we have KT, additional funding requirements, question mark, would Post Office have enough to cover? Important that department is aware as could be significant potential liability. Is that what you're referring to in terms of what you asked?
Yeah, I mean, this note obviously was a note that I hadn't seen, but that's what I do remember. I do remember that particular conversation at that meeting. So it characterises in some form my question.
That document can come down now. Did the lack of figures being provided at that stage mean that no account was being taken by the government of the overall value of the claims for the purposes of assessing litigation risk?
Well, at that particular time, my understanding was that Post Office had an ability to make financial transactions up to £50 million. Anything over that would need government minister sign-off. Again, I'm not a legal expert. I have no idea what sort of quantums of claims that could potentially be. But when I was told and when I understood that potentially 561 postmasters could potentially have had a claim on the Post Office, I was concerned that that could equate to more than, obviously, the £50 million. So I understood that any negative judgment against the Post Office would have had a massive impact on the finances and the taxpayer, and I was trying to be diligent into trying to push the Post Office into giving me some idea of what potentially that figure could be, and if it would have an impact on the Post Office, the functioning of the Post Office. Because one of the things that it seems, sort of reflecting now, looking back, I was actually really pleased to have the Post Office as part of my portfolio, because I thought it was a great business and I thought it was an interesting part of government. So it's something that, obviously, as an individual, I very much wanted to make sure that the Post Office could continue with its function and of public service, obviously separate to the litigation and obviously what I now know.
Could we have on screen, please, UKGI 30s21096? This is a shareholder executive risk register dated the 29th of June 2018. It's a little difficult to see because we need to click into the cells in order to see the text. So when I ask the lady to click in a box, the text will appear in full in the bar across the top.
Oh, okay, yeah.
If we are looking at this first tab, guidance, and cell C6, please, you can see the text here explains that this will be used as a graphical representation of top risks in capitals each team faces, and allows for different assets, projects, risks to be compared easily. And in big capital letters towards the end, please only include your top risks. And then if we go to tab 2 of this, please, which relates to the post office.
Okay.
So this was a shareholder executive risk register, which had that guidance and had this specific risk register relating to post office. Have you ever seen a shareholder executive risk register like this before?
So I don't believe I had until obviously the documents were shared with me, I think, a few days previous.
So these weren't shared with you at the time you were Parliamentary Under-Secretary?
I don't believe they were.
If we go to row 38, which is item 11, we can see here possible civil litigation against Post Office Limited. And then in column D, which is risk overview, we have civil litigation and or Court of Appeal processes judged that Post Office Limited has acted inappropriately or illegally, even in the absence of such a finding, ongoing risk that they continue to be perceived to have acted in that way. And then if we look at column E, impact of risk, on that same line, potential for significant compensation claims if civil or criminal courts rule against Post Office Limited. More likely, however, and certainly in the short term, is that this continues to be a significant distraction and cost to the business as they defend their actions. And then column H, we can see that the civil litigation has been given an impact rating of 4 out of 5. Apologies, hang on. A probability rating of 4 out of 5. And then we can see an impact rating there. Forgive me, if we can just scroll up so we can see the column heading. Seems to be current and previous, so referring to 2 different times of that being assessed. Scrolling down, please. So probability at 4 out of 5 and impact at 5 out of 5. Pausing there, was the scale of the risk ever articulated to you in those terms?
I don't believe that was.
If we look at column K, mitigation overview, it states Post Office Limited have external legal advisors employed on the civil litigation, including a KC. They continue to update UKGI through the board, where UKGI's NED sits, and directly to UKGI's legal counsel under a disclosure protocol that protects legally privileged information. And then at column P, further mitigating actions. UKGI have briefed Minister Andrew Griffiths and will keep ministers, SPADs and Permanent Secretary updated at key points through the new disclosure protocol, with Pol's legal counsel to provide an oral briefing on the 10th of September. So that's the meeting which was adjourned to the 17th of October. Bayes Legal are also up to speed and contributing to any advice to ministers, maintaining a position that government will not comment on an ongoing legal issue. Were you aware that UKGI considered the civil litigation against Post Office Limited to be one of Pol's top-rated risk on its asset register?
No, I can't say that I knew that.
That document can come down now. In terms of your experience of information flow from Post Office Limited, could we have on screen, please, UKGI 3021771? I'm going to page 4 of that document, please. The email towards the bottom of the page. You explain at paragraph 48 of your statement that you met with Tosin Adagan and Tom Cooper of UKGI on the 19th of November 2018. This email is sent the next day on the 20th of November, and it's from Oluwatosin Adagan to Sam White, who was one of your private secretaries. And it says this: "Hi Sam, thanks to the Minister for her time yesterday. Detailed below are the follow-on actions. Both Sams, please let me know if I've missed anything." And that first bullet point, weekly briefings as the litigation case progresses, verbal and written updates UKGI to action. Did you request those briefings?
Yes, I believed I did ask to be briefed. That was sort of normal for me to... I wasn't, I would rather have more information than I needed. So, you're better off having more information. So weekly briefings, I would have requested that at the meeting or as a consequence of the meeting. However, I can't guarantee that I did receive weekly briefings or verbal updates.
Did you request those because, as a matter of your general practice, you liked to have regular updates, or was there a particular concern?
No, I think it was more to do with my general practice. I knew, obviously, it was a big issue. It was something that it was important that I did have access to any new information or information as quickly as possible. So it would have been normal for me to have asked for regular updates.
Some emails follow above about how frequently the updates should be sent to your private secretary. And then towards the bottom of the page, I think bottom of the first page, there is an email dated the 23rd of November 2018 from Stephen Clark to Richard Watson and Tom Aldred, which says this: "Richard, to see further clarification below from the Minister's office on the Minister's request for trial updates. We'll submit once a week." And then that included a roundup of the week's news coverage, and also at the second bullet point, an update from Post Office Limited's legal team on trial developments over the past week. So the second bullet point here was referring to the fact that you wish to have updates from Post Office Limited's legal team in particular. Is that right?
So that would have been something that would have been formulated via the team or with my private office. I don't remember being specific about what I was requesting. I would have just asked for weekly updates and relevant information, not sort of give me information that had no consequence or was irrelevant. So these would have been ideas that would have been put forward by, as I say, I'm unsure of who would have sort of made those three particular requests.
Okay. Then the reply from Richard Watson is above. And it says, Stephen, thanks. I've had no reply from Post Office Limited Legal. I will chase them about it. I have not said to them that the Minister wants the update, partly because I rather feared that would cause the update to be less useful, or perhaps even be met with a refusal to provide one. And then Stephen Clark's email above. Thanks, Richard. I hadn't thought of that risk, but probably very wise based on past dealings. Were you aware that this was what was expected by UKGI, that a request for an update having come from a minister might result in a less useful update or a refusal to provide one?
No, I wasn't. And actually, you know, I would have, and if I had been, I would have been rather annoyed by it because, quite frankly, you know, they would have, you know, I would have, a refusal to give an update to the minister, I would have thought would have been absolutely outrageous. So if I had known about that at the time, or that there was a concern that that might not be the case, I probably would have raised that directly with them if they were actually refusing to give me updates.
It may follow from your answer, but was this something which you ever experienced directly at any point?
A refusal to give me information? No, I can't say that they refused to give me information. As far as I'm aware, should I say, because actually that was just from my direct contact with the Post Office for what may or may have been said to UKGI or officials within the team that I'm not aware of. That may have occurred, but with my direct communication, no.
Could we have on screen, please, UKGI 409455? This is an email from Tom Aldred of UKGI to others from UKGI dated the 5th of April 2019. And the first paragraph of the email says this: on Wednesday, Kelly met with Tim Parker. We also had a good chat with Kelly after Tim had to leave, where I was able to make a few points to her. I also walked over to the meeting with Carl, the new Bayes director, who seemed very nice. Then under litigation and recusal, the second bullet point reads, Kelly complained that she wasn't seeing enough information flow about the trial. We discussed as officials afterwards, and it seems the block is somewhere between her private office and her. Regardless, we should make sure that we are providing updates to her as soon as they are relevant. At this point, in April 2019, what information about the trial were you expecting but not receiving? Can you recall?
I can't say I was. I don't know what I was expecting. I just wanted to have, you know, good information, regular information, and obviously, rather than getting confused on the months again, I know we haven't spoken yet about the recusal, but obviously I was frustrated and angry about that. So I was expecting to get more timely and better information because ultimately, you know, as a minister who had the responsibility to answer the House of Commons or anyone that asked the questions, it was right that the information flow should be there, and but I don't quite know what I was expecting to see because I didn't know what I didn't know, but I just wanted that, you know, if I was getting a regular flow, hopefully there'd be information in there that would be useful to me in my role as the minister.
Can I just ask you in general, so that perhaps we can shortcut some of this? In November 2018, that was when the Common Issues trial started. Are you telling me that during the course of that trial, so that in the weeks effectively of November and December, you felt that you didn't get enough information of how that trial was progressing. That's point one. And then coming to this point in time, which is April 2019, we've now got the judgment in the Common Issues trial. Everybody knows that the Post Office lost. And so we're talking about the information you want to get in the Horizon Issues trial. So with those two staging posts in mind, so to speak, first of all, going back to question number one, did you feel you were properly kept up to date with what was happening in the Common Issues trial?
Thank you, Sir Wyn. I felt that I was getting some information, and at the time I would say that I couldn't, at the time, I couldn't make a judgment on the reliability or the level of information I thought that I was getting. I suppose my big issue was, obviously, after the judgment was made, it absolutely was clear that I wasn't getting the updates or the information that I felt that I needed to know, if that makes sense, if that answers your question.
Well, it answers my question about the Common Issues trial.
Yeah.
And then once you knew that the Post Office had lost that trial, to what extent, if at all, were you demanding greater discipline, if I can put it in that way, in keeping you up to date with what was happening in the Horizon Issues trial? We leave recusal as a separate topic for Ms. Price to deal with. But so far as the Horizon Issues trial is concerned, were you kept up to date in a more disciplined fashion? I can't think of putting it in any other way, during the course of that trial. I was given more information from, obviously, we had the policy team within Bays and my private office, and we were all sort of trying to keep abreast of what was happening. But I don't think that I was kept updated in a more disciplined way. Hence, whilst I was, I felt like I was continuously sort of asking for more info, more detail. Because clearly, the judgment, there were issues. There were clearly issues with what the Post Office was saying and what was happening based on that judgment. So, I didn't want to be blindsided as well, if that makes sense. So my determination to keep asking for information, asking for more detail, meant that, in my view, I thought that I would know what's coming, if that makes sense. All right, and then one last question before I hand back to Ms. Price. When you were saying more info, were you directing your requests to officials in UKGI or officials in the department, or to both?
To both.
Fine. All right, fine. Sorry, Ms. Price.
Not at all, sir. Ms. Tolhurst, and that document can come down now. A number of times in your statement, you touch on the relationship and engagement you had with UKGI specifically, to follow up on the point made by the chair as to who you were encountering difficulties with. And if we could have on screen, please, paragraph 88 of Ms. Tolhurst's statement. That's page 31. And you deal here with April 2019, the information, your private office saying that Tom Cooper wanted to meet you to update you on the litigation, and you saying you'd rather the updates were formalised. And then just going over the page, please. At 89, you say, I suspected by this time that Tom Cooper had gone native. My feeling was that he had lost his independence from Post Office Limited and was not providing effective challenge or scrutiny. What did you mean when you said Mr. Cooper had gone native?
Well, I meant that his objectivity had been lost, I suppose, in regards to, whether that's a fair characterisation or not of his approach. But that was my feeling at the time. That's all I can sort of say. And I think that had been borne out. Well, as I think I've said in my statement, actually, that and I know we want to come on to it. So, but what happened around that recusal obviously gave me cause for concern. And the reason I made a fuss about not wanting to meet with people informally is that, this was very, I wasn't ignorant enough to know, not to know how serious the whole litigation was. And, I sort of, because I'd sort of had become frustrated with the information flow, I didn't want informal information. I wanted information that was recorded and on the record, hence why I didn't want to have a random communication as I characterised it.
In relation to Mr. Cooper's request for a meeting, Mr. Cooper's evidence to the inquiry was that he would have benefited from a lot more in-person contact with the department, but in particular you. And his evidence was that the department had received briefings, but no questions came back. How would you respond to that?
Well, so even as a junior minister, I had a wide portfolio, and I had lots of responsibilities. At this particular time, we had a number of other challenges within my portfolio, not just the Horizon litigation. Absolutely, I want to meet with all stakeholders. But as one individual, there is a limit on some of the personal contact that you can have with those stakeholders. However, he had open and unfettered access to the base team. He also had the ability to speak with the Permanent Secretary. And any kind of severe concerns, in my view, shouldn't have been just purely reliant on having a face-to-face meeting with me. If he had had those serious concerns, or he had something that was important to the department, I would have imagined and I would have hoped that anyone working in that environment would have raised it with a number of other people, rather than only speaking to me, unless it had, it was something like a whistle blowing or something like that. So I would say that, yeah, absolutely. As a minister, I was always willing to meet with whoever I could within reason, particularly where it affected my portfolio. But, I recognise as well it wasn't possible with just the other pressures at that particular time to meet with, I wouldn't have been able to meet with him on a weekly basis. But that's a rather long answer, but I just wanted to give you the context of that. So I would say that's slightly unfair to suggest that because he didn't have as many face-to-face meetings with me, that there was no sort of feedback from my office, so to speak.
Coming then to your reaction to the Common Issues judgment and the recusal application, can we have on screen, please, paragraph 58 of the statement? That's page 21. And this is you being made aware of the judgment, and at 59, your immediate reaction was one of embarrassment. You were appalled that the judge had found Post Office Limited to have behaved so reprehensibly, and you felt utter shame on behalf of Post Office Limited in respect of what the SPMs had been through. You say you had a call the next day with UKGI about the judgment, and then going over the page, please, a call with Tim Parker, Alistair Cameron and Jane McLeod. And you set out some of the speaking points for that call, which reflect your immediate concerns. And then over the page, please, at the next paragraph, you describe the handing down of the Common Issues Judge as a light bulb moment for you. And you also say that your concern was what was going to change now the litigation, in terms of how the litigation was approached. A Dear Colleagues letter was sent to all members of the House of Commons after this judgment, wasn't it?
Yes.
And you explain at paragraphs 65 to 68 that you had originally recommended that some wording be included, which was subject to some amendments after comment from UKGI, but this wording was removed after input from Post Office Limited. Is that right?
Yes.
And the wording you originally proposed is set out at paragraph 66. And that wording was that the judgment represents a significant step forward, delivering justice for those postmasters who have been wronged. You provide your reflections on this at paragraph 69 over the page, please. And you say, looking back now, this is probably one of the areas where I should have pushed back and insisted on the original wording. Why do you consider that the original wording should have been kept?
Because I believe that actually it was the true characterisation of how, I felt as the minister at the time, but, and looking back, I wish I had pushed harder on that wording.
Coming then to the recusal decision, you say you were at this stage, the drafting on the Dear Colleagues letter stage, unaware of any suggestion that Post Office Limited might seek for the judge to recuse himself, and that you became so aware on the 19th of March 2019, when UKGI informed your office of this. Is that right?
Yes.
You say at paragraph 71 that your view and your official's view was that the application should not be made, and that you had very grave concerns about it. And 3 lines down, you say this: I believe that the Permanent Secretary, Alex Chisholm, took this forward and tried to discourage Post Office Limited from making the application. At no time was anyone at POL given reassurance that government would be happy with POL making this application. And you say quite the contrary. By quite the contrary, is it your evidence that you told Post Office Limited not to make the recusal application or not?
So I did not have any discussions with Post Office Limited directly about the recusal, but as far as I can remember, I don't remember having that direct conversation with them. However, what I do remember is that, my reaction and that of the others, other people within the department, that this was something that, was not something that I wouldn't support it. And I thought it was rather, madness really, but that I don't believe was directly articulated directly to Post Office Limited.
You deal at paragraph 73 with what you were told about whether government could or should be involved in the decision. And you say it was apparently not, however, within the department's gift to stop Post Office Limited from making the application. If it had been within your gift, would you have stopped the application despite the legal advice to the contrary?
Well, I believe I would have, because it's easy to say. It's easy for me to say that in hindsight, with what we know now. But my view as a complete layperson in this area, my feeling at the time was, you've had a judge that's made this incredibly damning position about the Post Office. So I was very surprised how that the Post Office first thought was to try and then recuse that judge. You know, as a layperson, I thought it was you know, something that was madness. Even what, you know, depending on what that legal advice had been. And actually, you know, I think that we wanted to make sure that this came to a resolution and that it was moved forward. And, you know, I was definitely concerned that anything like this could delay any further, you know, the progression of the case, to draw a line under it for the individuals involved.
Could we have on screen, please, WBON 301756? This is an email from Jane McLeod to Tom Beezer and Andrew Parsons, copied to others, dated the 16th of March 2019. And it says, "Many thanks. I have a call at 2:15 with our chairman, Al Cameron, and our minister, Kelly Tolhurst, and others. Although I don't believe recusal will be part of the discussion, I have been advised by the UKGIGC that government will not express an opinion on recusal, as they will not want the executive to be seen to be criticising the judiciary." Was recusal discussed on the call on the 16th of March? That was 3 days prior to the date you give in your statement for saying you were aware of it.
I genuinely, I can't remember the exact details of the call.
The suggestion that the reason government would not opine on the recusal application was said that it did not want the executive to be seen as criticising the judiciary. Did you personally receive advice to that effect?
So I don't remember I don't remember receiving advice to that effect. And actually, that's not how I was thinking. So my objection to the recusal was not worried about whether or not the government would be seen to be criticising the judiciary. You know, from my layperson's point of view, I thought that it was just absolutely the wrong thing for the Post Office to be doing, just because they had had a judge who had made a scathing judgment against them. So therefore, I couldn't understand how that would help in any way the Post Office's case going forward with any future judgment. So whilst that may have been the department's view, which I don't disagree with, I'm just saying that my thoughts at the time were very much in that place, as opposed to particularly concerned with what the judiciary may or may not have thought.
Having seen the documents which have been sent to you more recently,
Yeah.
Are you aware that Bayes Legal and the Permanent Secretary had taken the view that the department should not involve itself directly in the recusal decision?
Yes.
We needn't turn it up unless you'd like to see it, but there was an advice from Bayes Legal to Mr. Cooper that he should not take part in the decision on recusal on the 15th of March 2019. Were you aware of that at the time?
I don't think I was. No, I wasn't aware that that the advice he had been given was to not take part in that discussion. As far as I think I am correct in saying. However, I think this represents one of the concerns and one of the issues for me, because having the shareholder representative on the board not taking part in a significant decision that had the impact on the organisation of which we were the shareholder, and of a position that you know I didn't agree with, I suppose was a concern, is a concern and is a concern. You know, how were we able to, whether the advice was correct or not, I'm disappointed and I disagree with it. you know, because I believe that if you are a shareholder, if you are a board member, unless you have a very clear conflict, you should be taking part of those decisions. You know, it's a frustration to me.
Could we have on screen, please, UKGI 409321? Going to page 2 of that document, please, about halfway down. There is an email from your private secretary, or one of them, it seems, to Tom Cooper, which refers to brief discussion of this with Kelly over the phone, and as expected, she has concerns. And this relates to the recusal application being considered. Immediately, she said she would raise with Secretary of State. This is 19th of March at 17:15. I have flagged this to his office and I believe she has already contacted him. She has agreed that they shouldn't do anything until after the decision has been made at the board meeting called tomorrow, and that's the Post Office Limited board meeting to decide whether the application should be made. Is that right?
I think so.
And it is likely she will want another call with Tim Parker and Al Cameron after this to ask them to explain their reasoning behind their change of mind. So it would appear from this that there was a plan for you to have a discussion with the Secretary of State, but you had decided not to contact Post Office Limited to intervene in the decision before it was made. Is that right?
I don't believe I made a decision not to intervene and speak with the Post Office to. I don't believe that correctly articulated what that note meant at the time, because I was very clear on my position. Hence, whilst I had spoken to Secretary of State, it may have been. I mean, I can't. You know, I wouldn't have seen this message. I don't remember refusing or not agreeing to speak with Post Office Limited on this issue.
Well, did you make any attempt to speak to Post Office Limited on this issue before the board meeting decision?
So my belief was that I understand, if I remember correctly, that Alex Chisholm, who was the then permanent secretary, was going to speak with the board, or not necessarily speak with the board, but it was left with him. But I think, you know, very clear that I definitely didn't try and avoid or refuse to speak to Post Office Limited on this, because if I had felt that I had had an opportunity to influence it, I would have taken it.
That document can come down now. You received a submission on the 11th of June 2019 about the Post Office litigation. Can we have that on screen, please? It's BEIS 5075. If it helps, you address this submission at paragraphs 124 to 128 of your statement, if you want to refer to them. So this submission, you are one of the recipients, and under summary, at the industry meeting on the 4th of June, you, Secretary of State, so being the top recipient, asked for advice on how the ongoing Post Office Limited litigation could be brought to a swift and satisfactory conclusion, ensuring postmasters who had been treated unfairly were appropriately compensated. Does that reflect your wishes at the time as well?
Yeah, absolutely.
And the potential options which were available to you are set out on page 4 of this document. Can we go to that, please? And it refers you to a table at Annex A, with a range of options, and they were said to range from challenging the existing board, Post Office Limited board, to change their litigation strategy, to more fundamental changes such as replacing the Post Office Limited board or BEIS assuming control of the litigation strategy. And then the risks are explained at 18 of more vigorous action. And those included forcing further changes to the leadership team, risk disrupting the progress Pol would have made in other areas of operation of the business. Making public statements or directing Pol to take certain action could weaken their negotiating position in relation to settlement and make it harder to stick to the existing BEIS line that this was an operational matter for Pol. And then the recommendation was that you choose from options 1 to 7. And options 1 to 7 were the less fundamental changes of the options, is that right?
Correct, yeah.
And they're the ones, I won't go to them for the sake of time, but the ones that you set out at paragraph 125 of your statement.
Mm-hmm.
Looking at the points made in paragraph 18, was there pressure to maintain Pol's financial success as a priority over the concerns and interests of sub-postmasters?
I don't believe so. That was definitely not something that was my approach. I would say it was never about protecting the post office over sub-postmasters. It was about making sure that, as a people, as a taxpayer responsible body, we had confidence in the leadership and the processes, and that the right decisions were being taken.
In respect of the line referred to here, that the litigation is an operational matter for Post Office Limited, did you agree with that?
I did agree with it, because at that particular time, because obviously there was an executive team running the post office, and they were responsible for the operations and delivery of the post office as an organisation. And, as far as I was aware, none of the officials within BEIS, notwithstanding whatever the officials in UKGI had been informed of, that it was something that they were leading on, and that it was their responsibility to resolve as well.
Wasn't this a classic example of an operational or contractual matter which was concerning ministers at a policy level, such that simply leaving matters to Post Office Limited on the basis they were operational was not a defensible position?
I think in looking at it from hindsight, we could say that absolutely, I think we can go on. I'm sure you'll pick up with me about the future and, potentially what is wrong. But I think that at the time, all I can talk about is at the time and when I was involved, and I did think it was an operational matter. Yes, I was concerned in relation to policy and how that would affect policy, how that would affect future decision making. But I didn't believe that we could take operational responsibility for it, because obviously we weren't appraised, or we weren't, or I definitely wasn't directing the legal advice, or I don't even know what the questions were asked of the legal representatives when this legal advice was given to the Post Office. So I think that absolutely it's what we know now, and absolutely it was it's a mistake that it shouldn't have been. Government should have had better oversight of what was going on at that time.
Why ultimately did you choose not to make radical changes to the leadership of the board? So the harder options that were in the submission.
So I thought about this obviously since writing the statement, and I don't remember exactly, other than I don't remember exactly why I went from being very determined in my views to move on the chairman and change the board, that we didn't end up doing that. Other than that, I would imagine that there was no appetite for that within the department, or the advice that I was being given by the Permanent Secretary and the team at the time. It would have been seen as a very sort of, I think I described it in my statement as a nuclear option. And, this was my first ministerial role, I was really keen to make sure that I acted appropriately. And obviously I did take note of advice and that I was given. However, I will caveat that in the sense that whilst I take note of the advice, if I thought that I had an opportunity to do it, I would have taken it. So but I can't explain exactly why I didn't go for that particular option.
I'd like to come finally to your reflections, and starting with paragraph 194 on page 70 of the statement, please.
Before you do that, Ms. Price, could I just check with you? Are we having a sort of second break, or are we going to the end now?
So I think we are going to have another short break, after which there'll be some questions from core participants. I will only be a couple of minutes further with my questions, at which point I was going to suggest at 5 we take a break to 5 past.
Fine, okay.
So page 70 of the statement, please. In the interests of time, I won't read out all of paragraph 194, but that is the paragraph that essentially deals with what you think was inadequate information being provided to you. And then on 71, we have 198 and 199, where you make some observations in respect of the governance structure in this instance. And in sum, is it correct that your position is that, first, the government was not given sufficient information to act appropriately, and second, the structures in place tied the government's hands as it had no directing power? Is that a fair summary?
Yes, it is.
Is it right, though, that in terms of access to information, the government had a representative on the Post Office Limited board, and you were in a different position in terms of knowledge of matters after the Common Issues judgment as compared with before?
Yeah.
The government also had that nuclear option of removing the chair in extremis. Was there any conversation about the responsibility of government and collective cabinet responsibility in the context of litigation being defended in a way which it appears you believed was increasingly indefensible?
I can't speak for, I don't know whether that was discussed, and I definitely, I genuinely can't answer the question about the Cabinet's involvement or whether that was discussed at that particular point. I think for my, if I could just, I remain concerned, and about, at the time I would have loved to have had powers of direction of the Post Office, actually, because if I am furnished, I was more than happy to take decisions. So I think that fundamentally, the structure of the Post Office and the way it's been set up, and also even that connection between UKGI and the department. So, for example, you know, the UKGI shareholder representative wasn't a member of the department, so it wasn't someone that was directly answerable to me, for example, or the Secretary of State. I think I was operating within the system that was there, and whilst I accept that, you know, the structure of the organisation, you know, I had to work within those boundaries. Yes, it was a frustration, and you know, that's something that I believe that maybe if it hadn't have been set up in that way, we would have, well, I would like to think that this may have been resolved early on, because ministers would have had that ability to direct and take further decision. I mean, I think even, sorry to sort of labour the point, but just going back to even to the point where the minister had to sign a protocol for information sharing. I mean, even me coming in as a layperson, I thought, well, hang on a second, if I am the minister responsible, why do I have to sign a document to say that I'm not going to share, you know, so that I can be given that information, when actually we are the shareholder, we own the organisation. So I think that, and you know, and I would like, I'm also very keen to see the outcomes of the inquiry in relation to the recommendations that are made, because obviously it's something that, you know, has caused me, you know, concern and a lot of reflection since the process, since I was a minister in the department.
So those are all my questions for Ms Tolhurst. It is between 5 to and 4 o'clock. But I wonder if we could come back between 5 past and 10 past if we're going to get through the questions.
Yeah, by all means. I'm prepared to stretch 4:30 a little, but I just so that everybody knows, my absolute limit today is 4:45. So either questions have to be asked within that time frame, or some other arrangement has to be made. All right.
Thank you, sir. Understood. Good afternoon, sir.
Good afternoon.
We have questions from Mr. Steen and Ms. Patrick. I'm told there will be 12 minutes each.
The precision grows. All right.
Sorry, grateful. I'll start my 12 minutes now. Ms. Tolhurst, my name is Sam Steen. I appear on behalf of a very large group of sub-postmasters, partners, mistresses, and their and employees in branch offices. You said towards the end of your evidence, when you were being asked questions by Ms. Price, that you are looking forward and you're very keen to see the outcomes of the inquiry in relation to the recommendations that are made. Okay? Mm-hmm. Now, if you like, the lens through which I'm going to ask you a number of questions is that one.
Okay.
That recommendations, how can we improve? What is going to be better in terms of government, the way government operates? All right?
Okay, thank you.
Now, to help with that, and as a starting point, can I take you, please, to paragraph 35 of your statement? Go to that, please. And you'll see there at paragraph 35, that's page 12, Ms. Tolhurst's statement, that you're referring there to a briefing authorised by Poll for 17th of October meeting. The briefing was extensive, although section 2 setting out the background to litigation was relatively short. You go on to say, I did not understand this to be a meeting about litigation strategy or the merits of the claim. So I'm going to take you now to that briefing. Okay. And if we can go to that, that briefing is to be found at POL 000-22976. If we look at page 1 and have that on the screen, that would help. So this briefing paper, as you'll see, and you had this in your pack, it's a meeting on the 17th of October 2018, and it has a reference to yourself, Mr. Tolhurst, Parliamentary Under-Secretary for the Department of Biz, etc. Okay? So you're joined and taken on this ministerial post, I think, in July of 2018, so you'd had some time to get familiar with the role, but not very much time. All right? So the particular paragraphs I'd like to ask you questions about at page 10, paragraph 3.3, please. Please. So we drop down just slightly from there. Thank you. Right. So 3.3, the most important common issues concern the liability of agents for losses. And then it goes on to say this. The claimants argue that Post Office needs to show that a postmaster's actions have caused Post Office to suffer a net economic detriment, not just that the branch's accounts ostensibly show a shortfall. Post Office's position is that if a shortfall is shown in the branch's accounts, then, absent any cogent evidence to the contrary, the postmaster is liable for that shortfall, given that they are responsible for conducting the transactions recorded in those accounts, and for the Post Office cash and other assets used. Paragraph 3.6, please. So over the page, page 11. Post Office's external counsel believe that Post Office has the stronger arguments on most of the common issues. Okay, so you're being given a pointer here within the briefing document to what are strengths and weaknesses, all right? However, they also caution that the areas likely to be most problematic for Post Office are the clauses dealing with suspending and terminating postmaster contracts, including length of notice, withholding remuneration during the periods of suspension, and imposing liability for branch losses. Okay? So you're being given a steer as to areas of real concern for the litigation. And one of the steers that you're getting, and an area of real weakness that's being identified, is regarding this question of how shortfalls are accounted for within branches. So we add up the pieces we've got so far. You've been in post for a few months. One of the jobs that you had to do is essentially look after areas that relating to the Post Office, yes? Mm-hmm. You need to say
Sorry,
yes
sorry,
or no.
sorry, yeah.
Thank you very much. You understood that the Horizon system was essentially the working operating system for branches, and that it was an accounting system run by the Post Office, yes?
Yes, yes.
And you've lived, I think you've lived and worked in Kent for, and we were an MP in Kent. You're as familiar as we all are with small branches of post offices up and down the country.
Yes.
And you've said already in your evidence that you were aware that these branches were small businesses as against a much larger corporation. Okay. So what we've got here, it seems, in the briefing, do you accept this, is you're being warned, look, there's a real issue about this question of how we impose liability on those small businesses. Do you agree that that's what it says?
Well, I agree with it. That's what it says, because obviously that was the nature of the litigation and the dispute, and it was obviously an update of the litigation. Hence, the first sort of big brief I'd been given since taking on the role.
One of the things about this brief, and if we flick through it, we can see that it's something like 50 pages. It's quite dense stuff. Okay. So we can see that by being given this amount of material, without it necessarily identifying, look, it's Tolhurst, this is the hot topic. If we lose this, this could be curtains for the Post Office, because the very identification of who's responsible for paying these shortfalls is pretty much an essential foundation of the litigation. Now, that doesn't seem to have happened. It doesn't seem to have got onto your operational radar as being, look at this, watch out for this problem. Do you agree?
So, yeah, I would agree. So, for example, I mean, one of the ways I work anyway, and I had it a number of times in that portfolio, I had to get to grips with very large documents or points within government that I had no experience of before. So I'm absolutely fine with reading documents, taking it in. Obviously, there may or may not be some questions that I may or may not arrive out of reading what's put in front of me. But you're quite right. So I don't remember or recall anyone, when I first looked at this brief, saying this is going to be a problem, this is something that that the Post Office, will have such a bad judgment on. And the reason I say that is because obviously I had this going into that meeting, and then having those assurances that there was confidence from the Post Office that they were right. And obviously, whilst I'm not a lawyer, I don't have any legal experience, and I wouldn't, and I'm sure the civil servants wouldn't have liked it for a minister to have, they would always caution against going against sort of legal advice.
But here, Ms. Tolhurst, the legal advice actually is, look, we may well lose on these issues. So here's an area whereby the owner of the Post Office could have said, hang on, if we could, what does it mean if we lose on these issues? How bad is that?
Yeah.
Now, you say in your statement, I don't want to go to it because of time limitations, paragraph 57, it was probably, this is March 2019, probably at this time I was first told of the core issues in the Horizon Issues trial. Well, actually, when we go back to this briefing, you are being told about these core issues quite a lot earlier than that. Now, where has this gone wrong? Should somebody, and if so, who, said to you, look, if we lose this, this really is significant for the entirety of the litigation, the company that we own. Who should have pointed it out to you, do you think?
Well, actually, sorry, so I think that it was, so actually there's not one person that is, sort of, it's a failure of the whole system, because actually I think, as I said earlier in the evidence on the answer to...
I said who. You may want to say role or position. No, my fault.
So in answer to Emma Price's questioning, and I said actually that, severe... I shouldn't have been the first or the last person to, or could have been, I shouldn't have been the only person to have had that message. So that, if there was a severe issue, I would have expected it to come through the shareholder, the government shareholder representative on the board, because ultimately that's their role. But but that should have been something that had been discussed widely. It would have been something that you would have expected UKGI to be over, our permanent secretary to be over. It should have been, you shouldn't have had a junior minister chasing around or sort of, working out what information or what not to believe. And I think that's the fundamental issue.
Okay, can I tackle
Sorry.
that? No, that's fine. Can I tackle that? Paragraph 78 of your statement.
Yeah.
Sir, page 28.
78, yes.
So paragraph 78, page 28, you're talking there at the beginning of that paragraph about the arm's length model. You're talking there about, I think if I recall correctly, about the recusal application and legal advice, which I will, if I have time, I'll just quickly go to in a moment. But this point about junior minister point that you've just gone to, you say this at paragraph 78. The situation at that time, arm's length, senior counsel legal advice and so on. This did not feel enough for me as a first-time junior minister to go against the advice. In my mind also was that in taking that sort of action, then you go on to talk about other issues that you're saying are in your mind. But it's not just in recent history that there's been a churn of ministers. There is a frequency of change of ministers across our system.
Yep.
And indeed, you have occupied various posts, quite short periods of time. So you're quite a good person to ask about this. It's frankly quite difficult to get a sense of governance from ministers that are constantly changing, who are constantly having to be briefed, worked up in terms of knowledge, and then start making decisions. Because you end up in challenges like this. I've been told by senior legal people, X or Y. What do we do to change that? How do we make sure that somebody actually gets a grip on these things?
Well, I think specifically around the post office, because I do agree with your point, in regards to churn and ministers getting up to speed, being given that information in order to make proper decisions. But I think where the post office is concerned, it is slightly different, because and this is where, and it goes, I think I've said it in my statement, but excuse me, I can't remember the paragraph without looking it up. But And my only sadness is that Post Office Limited wasn't what I would call a true arm's length body of government, where actually, as the junior minister, I would have had powers of direction and absolutely the position to be able to ask and demand information or make a judgment. And for me, even though it was my first time ministerial appointment, I've spent my whole life taking, living with the consequences of the decisions that I make in my work life. So if I had been in a position where I could make decisions, I would have, it's a phrase I've used, I live or die by my sword. And if I made the wrong decision, I'll take responsibility for that. If I made the right decision, all very good. And that's one of the things that and for me, this is the problem, the fact that it was a limited company, not a true arm's length body of the government. And therefore, I personally, if I can say, whatever, I hope that one of the outcomes of this inquiry is actually the post office structure is completely changed.
Let me briefly, and I will finish on this, legal advice, paragraph 73 of your statement.
Sorry. Yep.
Now, paragraph 73, it's an example of legal advice that's being given, but you refer generally in your statement, as you have in your evidence, to strong legal advice that you've been given. Effectively strong legal advice to stay out of it, to not interfere with this particular body. Now, for the people that I represent, that feels mad, because there you are, you own, essentially, as the government, you own the post office. Now, the legal advice that you're being given, if you look at what you have there at paragraph 73, which is reasonably good by way of a reference to the type of legal advice, it's not legal advice that is saying that there's legislation that says you've got to keep out of this. It's not cases that say you've got to keep out of it. This is more kind of, we think it might not be a bad idea if government sort of keeps away from it because we don't want to get burnt type legal advice. Yeah. This is barely legal advice if it's a legal advice at all. Why did you feel that you had to follow stuff that isn't actually rooted in law?
Well, because as someone who is not an expert, and particularly in regards to legal matters, and I can't profess to be so, when you are given, if you are given advice from trusted, experienced, qualified, or people that you perceive to be qualified, I had nothing to, at that particular time, or especially in short time, you've then got to rely on being able to have other advice in order to challenge that. And actually, and one of the challenges, going back to your earlier question around, the response, I'm not making excuses, please don't think that that's the case, but, there is so much going on, there are so many demands on your time, you only have a certain amount of bandwidth, so you do have to rely or put some trust in some of the information that you're given by your advisors. And that's not a get out, I'm not trying to negate any responsibility for not challenging, because absolutely that's the role of a minister to challenge. And, others will judge, whether I was right or wrong. I just tried to act in the best that I could at that time.
Do you agree that ministers in the future need to look at the question, which is this actual legal advice? Is this about the law saying something that can or can't be done because that's a legal principle, or is this other types of advice which isn't necessarily from anything other than coming from lawyers?
So I agree.
No further questions. Thank you, Ms. Tolhurst.
All right, thank you. Just one follow-up on that before Ms. Patrick. It seems to me that your core complaint, when you talk about what frustrated you, was your inability, in effect, to direct the post office what to do in certain circumstances. So I take it you want me to look at the powers of direction, if any, which currently exist, and whether they should be greater.
Thank you, Sir Wynne. Yes, I would...
I got the point, that's fine. Yeah. Ms. Patrick.
Thank you, sir. Ms Tolhurst, my name's Angela Patrick. I asked questions for a number of sub-postmasters who were convicted but have since had their convictions overturned. You can see Mrs Hamilton to my left and Miss Hall and Mrs Henderson to my right. Mm-hmm. I have two matters, and I think I'll only take you to one document if I need to. And the first I think we can take quite quickly. Ms Price has asked you questions about your concern that you had around the time of the recusal, so spring 2019, that Mr Cooper had gone native and that you were having problems getting information through UKGI. She's also asked you a general question about cabinet collective responsibility. Mm-hmm. Did you raise your concerns about Mr Cooper having gone native, or your concerns about blockages of information coming through UKGI with any more senior ministerial colleagues, your Secretary of State or anybody at the Treasury?
So yes, and absolutely, that's why we ended up with the paper, which gave us a number of options and on how potentially we could move forward. One of the things that I think I referred to in my statement is that I was concerned about what was happening at the board for the shareholder representative, and I was very annoyed about the recusal. And my initial reaction was, I know we didn't end up in that place, but my initial reaction was I wanted to change the board, and I wanted advice on how I could remove the chair. If I look back, if I had taken that decision or enforced or got that decision made, what would have, would that have affected things? I don't know, because we don't know in hindsight. I do believe I raised concerns, and hence whilst I also mentioned in my statement that I didn't want informal meetings, I wanted it on record, the information that I was being given, because it wasn't until...
Can I stop you there? We've got your witness statement. I just want to say, you did escalate it. Yeah. Now, we're going to hear from other ministers. Mm-hmm. that kind of communication where you have concerns about what your briefings are happening, how they are, whether the role's being performed properly, that's something that any minister could do. They can share concerns with other ministerial colleagues, they can raise it, they can escalate it if they've got particular concerns at any time. That's fair.
Yeah.
Secondly, I just want to return, again in that general sense, to what you say about the powers and responsibilities of government in respect of Paul. And I won't take you to a document I was going to take you to, just to save time. It's a document called, I'll give the reference, Paul 20259978. And it'll have been very familiar to you, Minister. It's a long list of PQs with your name on, where you say most of them have answers which start with Paul is wholly owned, but Paul is an independent commercial business. That's a line that would have been very familiar to you from the start of your role. And it's reflected in the evidence you've given to the inquiry today about your concerns about the arm's length role of the Post Office and the limitations and the responsibilities and the ability of government to direct. And again, you've said about operational issues with Miss Price, and you've addressed it with Mr. Steen. I just want to go back to taking hindsight out of the picture, what you and other ministers would have known at the time you were in post. You'd have known that the Post Office was wholly publicly owned.
Correct.
And you, of course, have addressed the fact that the government would have had that nuclear option that all shareholders have. They could have got rid of the chair and they could have got rid of the board at any time. You're nodding. I think you have to say yes.
Oh, yeah,
or no.
sorry, apologies. Yes.
And you've said repeatedly, like others have, that you would have been deeply conscious about the important role the Post Office played in the community. You would have known that the Post Office was a business with public commitments that had to be discharged.
Yes.
Commitments that the government was very conscious of. Now, you knew the government had passed the 2011 Act and was working with a goal towards mutualisation for the Post Office. You would have known that in your role, wouldn't you?
Yes.
Yeah. Now, the inquiry's seen repeated correspondence appointing repeated Post Office chairs where ministers write to those chairs and set the goals they see for the business. You would have known as Minister that government was essentially setting strategic goals for the business that they were essentially working through the chair to achieve.
Yes.
And you knew that the Post Office continued to rely on a really important public subsidy.
Yes.
And one of the goals was to reduce that public subsidy.
Yes.
Yeah. This was no ordinary independent commercial business, was it?
No.
No. So was repeating that line, as government often did, including in PQs, really just a convenient way to avoid the true picture? That the government didn't want to face up to the fact that the Post Office was a state-owned body which had, or at least potentially may have, unlawfully prosecuted hundreds of innocent men and women for years.
So my response would be that I don't believe that, I definitely wasn't using it as a convenient excuse not to get involved. I fundamentally believed that I was unable to. And hence whilst I've made the comment about what I believe that really, if the government are ever in a position where they own it doesn't work. Government can't be a shareholder of an organisation without having fully operational responsibility as far as I'm concerned.
Can I stop you there?
Sorry.
I'm very conscious about time.
Yeah, sorry.
And I just want to go back to that notion of the nuclear option.
Yeah.
That the only option the government had was that nuclear option to get rid of the chair. That nuclear option, whether it's owned by the government or any other majority shareholder, that nuclear option gives you leverage, doesn't it?
Yeah.
And you had serious concerns about the direction of the litigation, you had serious concerns about Tom Cooper and about UKGI, and you say you did something about it. Now, we'll look at that. But if you or any other minister really wanted to do something about what the Post Office was doing, whether in the litigation or in its other conduct, you really did have options short of the nuclear, didn't you?
Yes, I mean it's highlighted. I've absolutely been clear about that, and you know, if I heard, you know, I said earlier on in evidence that, you know, I don't know why I can't. You know, I know there wasn't an appetite for it. However, actually, I was someone who, you know, I would have fronted out, even if it had been the wrong decision, I would have fronted that out. And, you know, that's one of the, I don't know what would have happened if I had have taken that decision, and if I hadn't have sort of been discouraged not to. I don't know if it would have had an impact for the postmasters and subsequent subsequent operations. And that's something, you know, I can't answer. I can only explain what I was thinking and where I was at the time. But you're right. But I mean, I can only speak for myself. I can't speak for other ministers. You know, for me, it was definitely it wasn't an excuse not to get involved, because if I felt that I had justification and evidence to back up a decision, I would have taken it.
And just to bring it back to the very simple question, you focused in what you said to Mr. Steeden, to the Chair, and in your witness statement about government being limited to that nuclear option.
Yeah.
It wasn't the only option government had, was it? There was leverage.
Well, I think I've sort of explained that, you know, it was leverage, you know, I asked questions, but
Indeed.
It wasn't enough.
Thank you. That's all the questions I have, Ms. Tolhurst.
Ms. Tolhurst, just so that I'm clear about this, the so-called nuclear option, was that something which you personally could have done if you'd thought that to be the appropriate course of action, or was that for the Secretary of State?
Well, I think it would have been under a direction of the Secretary of State. So when
So ultimately, he or she would have had to agree with that option.
Yeah, absolutely, and they were the options that were presented to us. I mean, it's my characterisation of nuclear option.
No, I follow that. I just used the phrase to identify the process.
Yes, yeah, it was.
All right. Thank you very much. Is that it, Ms. Price?
It is, sir.
Well, thank you, Ms. Tolhurst, for making a very detailed witness statement and for answering a good many questions this afternoon. I'm very grateful to you on behalf of the inquiry.
Thank you.
So we'll resume again at 9:45, I take it, tomorrow with Mr. McFadden. Is that right?
That's right, sir.
All right, fine.
Thank you.